My lord, in this matter, I am appearing for the petitioner. My lord, what happens, my lord? They have filed one opposition. My lord, I took some time, my lord, to ready the reply. So, my lord, kindly give me 2 weeks time to file the reply, my lord. Mr. Bhattacharya is a junior, my lord. His father was expired, my lord. That's why, my lord, I am paying. Though, my lord, everything has been, he has just joined.
For whom?
For the
Appearing for
petitioner. Respondents has already filed their opposition.
Private respondents.
Private respondent.
पूरा कोता है private respondents.
Aspirate for comma. Aspirate for comma. The time to file the affidavit in reply. Rupam, aspirate for the time. Aspirate for comma. The time to file the affidavit is extended for a period of 2 weeks from date. It's the matter record. For a period of 2 weeks from date. And lease the matter for further consideration. 3 weeks. Yes, why?
No, this is the affidavit directly came to me by email from Delhi. He has also
Lordship, I am appearing on behalf of the Union of India in this matter. Lordship, one mail has been received, but I have seen this in this mail. Lordship, some mistake has been taken place.
You are appearing for whom?
Union of India, Your Lordship.
Yes.
Lordship, regarding some mistake has been taken place in respect to cause title, Your Lordship, in this mail, Your Lordship. It is
just remind us what.
My lord, may I just say, my lord, the appeal had been disposed of with the direction on the central government, my lord, to file a report in the form of affidavit, which was to be considered by the learned single judge to dispose of the writ petition finally, my lord. Now, my lord, they are not filing, my lord, and there is a direction in the appeal court's order that the writ should be disposed of considering the amendments made in the affidavit, my lord. So, my lord, I had filed this application seeking, my lord, closure of the right to file the affidavit so that the writ can be heard and disposed of. Lordship, may kindly take up the order date is 9th of April 2024, my lord. Or, my lord, in Can 2 is having, my lord, page number 17.
Can 2?
Can 2 is my application, my lord, respondent number 1 and 2, writ petitioner. Number 17.
You are for the private respondent?
No, my lord. Please, my lord. Private respondent 1 and 2, my lord, the writ petitioner, my lord.
Where is your appeal?
My lord.
This application filed by him.
Can 2 is filed by me, my lord.
Where from your cost title you have not indicated anything? You don't have a file. Where is it that this is an application filed by you?
My lord, page number 11, my lord, it says, my lord. After the learned Chief Justice, Honorable Chief Justice's name, my lord, I have stated, my lord, stroke respondent.
Who are 47, 48 in the
central government, my lord. Central government respondent.
Yes, what you are showing us?
Can you take up page 17, my lord?
17?
17.
Yes.
By this order, the appeal was disposed of.
Yes.
Paragraph 3 and 4 is, my lord, relevant only. Page 8.
না না, এটা তো আমি এফসিআই।
আমি FCI
আপনি এফসিআই?
না না, আপনি FCI না, এটা সেন্ট্রাল গভর্নমেন্ট, এডুকেশন
কি
সেন্ট্রাল,
বাজে বাজে বকছেন?
FCI না।
আপনি জানেন না? আপনি এফসিআই না? আমি এফসিআই।
Paragraph,
3 and 4, my lord. Page number 18.
who are the added respondents?
The central government respondent number 47 and 48, my lord. They were added by
Subsequently added.
the learned single judge, my lord.
অর্ডারটা দেখো। Page 45 of the application is the actual paragraph by which that respondents have been added.
Page 45, paragraph
Paragraph
36.
Now they were asked to file a report within 3 weeks
3 weeks, my lord. No, they did not file.
upon prior service. They did not file it.
No, my lord.
And the appeal was disposed of, sending it back to
The learned single judge, my lord.
single judge on consideration of the affidavits to be filed by the added respondents.
Yes, my lord. No, since the
So where is the order of the single judge?
single judge, my lord, next page, my lord, page 20, it starts. The addition of the respondent, it's at page 45, my lord. Learned single judge.
Sorry. So,
Yes, my lord, page 20, it starts. Page 45, lordship may kindly see. Page 45, paragraph
Oi.
36.
টাইপ কত অরিজিনালটা এসছে?
Open the instance.
এটা দিয়ে দিই। আচ্ছা। তুমি একটা copy দিয়েছো
It's
নাকি?
annexation name.
Annexure আছে নাকি?
No, no,
Annexure নাই?
what is it?
Annexure আছে?
Yes, 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 yes.
দিয়ে দিই।
so what order did the learned single judge pass?
And kindly
Ultimately-
comes to page 45, my lord. The operative, last portion, my lord, I'll just show you, lordship.
Yes.
Paragraph 36.
Yes.
The learned single judge will added the central government as the respondent, my lord, and then asked them to file an affidavit so that the writ petition can be disposed of finally.
On the basis of that.
Against this
report is
order,
ready.
FCI,
If say preferred an appeal,
I see. Why did they prefer appeal?
my lord, because this order, my lord, really affirms my legal right in the writ petition. But the consequential benefits were not given, my lord, because of this conflicting stand taken by the respondents, my lord, by the FCI. Because I am claiming, my lord, the benefits of the central liberalized pension scheme, my lord, the central government liberalized pension scheme. In their affidavit in reply, my lord, they have stated, opposition, my lord, they have stated that they have extended these benefits, my lord, but later on in course of the hearing, they say they have not extended these benefits. There was a conflict, my lord, that is why this conflicting stand has come up, my lord.
The fact is this
So
was
clarifying this, my lord, they were asked to file an affidavit. And without this affidavit, the writ was,
We are on behalf of Union of India, my lord, report is ready. We are ready to file this.
The learned single judge gave an opportunity to the added respondent to give two information
yes,
to
my lord.
identify whether the food transferees who are in service of the respondent number one on such and such had been afforded any benefit under the
Liberalized
liberalized
pension scheme. Yes, my lord.
whether this information is required for effective adjudication of
Yes, my lord. This is vital, my lord.
this was felt by the learned single judge.
Yes, my lord.
So why you are standing in the way?
But I am not standing in the way.
as the Union of India is delaying to file this affidavit, that's why the learned friend has filed this application before this honorable court and saying that this thing.
Now
In
this
the-
Where have
affidavit
you
and
stated
report is
that?
ready, my lord.
Where have you stated that in your application?
Well, I'll show you. Page 12, paragraph 4, my lord. মানে এখনো শেষ হয়নি বলা, একটু দাঁড়ান, আমি একটা
just. I know.
3 weeks time was given by the appeal court.
yes, my lord.
না, আমি আজকে জমা দিয়েছি।
হ্যাঁ, ধরুন যে ওটা
Constable তো ভুল
হয়েছে মানে অ্যাডভোকেট চেঞ্জ হয়ে যাওয়ার জন্য একটা ফাইল হয়নি। ওটা বলছেন দেরি হয়ে গেছে, জজ সাহেব বললো আর দেবো না।
এমনটা
ফলটা কই?
যান্ত্রিক এই কারণে আসতে পারেনি আমাকে বারবার করে বুঝছেন আমি কিছু জানি
Now, what is the 2nd February 2024 in your prayer?
And learned single judge asked him to file a report, my lord. This communication came, my lord, which we received from FCI, which answers those queries, my lord. So, my lord, I had prayed that if they are not willing to file in this affidavit, my lord, this can be taken into consideration by the learned single judge to dispose of the writ petition, my lord.
I see. Now, that communication was denying you the benefit of the liberalized scheme.
Not denying, my lord, they have stated, my lord, kindly comes to, my lord, page number, it's here, my lord. Page 47, my lord, of this
No, that-
application.
the
It's
affidavit
not
was-
denying,
I
my
have
lord.
read it.
It's only state when it was extended, my lord.
Page
47 of
of
this
your
application,
application.
of my application.
That is the trial judge's order.
No, my lord, 47 is that communication, my
I
lord.
see.
Annexure C. I got this from the stay application filed by FCI in this appeal.
So this you placed before the learned single judge.
Yes, my lord, I had placed, but because there is direction to file an affidavit report in the form of that is not there, learned single judge has asked
Now,
me to.
affidavit has been
I have gone
Prepared,
for the
my
last occasion, you also directed me to take a copy. I have taken a copy. The original has come
original has come my
by
lord
the Government of India's advocate.
and I am
They directly forwarded to me in my email. As I am an advocate for FCI, they directly forwarded to me in my email.
no, that order was passed, that this affidavit has been filed before the learned single judge.
No, my
Not
lord.
single judge before the appeal court. Now, my lord, the last occasion, your lordship has been pleased to direct me that if the affidavit has been affirmed, then give me a copy, I shall read it. For
Yes.
that, I have given the lordship the copy. The original now has come.
now the original has
But
also
affidavit has not been affirmed as
Yes, my
yet.
lord, yes, it has
Yes,
been affirmed.
Lordship,
it has come my
But
lord. It has come.
due to certain mistake, your lordship, in respect of false title.
change of lawyers my lord
Where is the original of it?
due to original is with me my lord I am due to file this
This is the original.
I must be candid before your lordship. I am not on behalf of the Union of India. I am just requested by Mr. Mukherjee to hand over this. Mr.
Who are you
Mukherjee,
appearing?
Shyamol Mukherjee.
Lordship, I am a Union of
Mukherjee
India
is
interested.
How many persons will appear? You
As-
are appearing, he is
No, my lord,
appearing.
I am on behalf of
Problem
Mr.
is this, my lord,
Mukherjee.
as the Union of India advocate was not taking steps, well, we have written a letter to the Government of India that please take steps, otherwise huge burden is there.
Financial.
That's why so many advocates have been immediately appointed, my lord, who will ultimately
No, I am in a fix, my lord. I am just requested by Mr. Mukherjee, who is a senior person.
ultimately argue, my lord, I don't.
Records reveal that the
Why so much application?
One is a restoration, others are substitution, setting aside abatement, section 5. Before when I start, my lord, I am for the private respondent, my lord. Today, my lord, this is a transfer brief. Today I have for the first time, my lord, but today I have no vocal adnama. That's why, my lord, I am praying short adjournment, my lord.
কতদিনের ডিলে? How much?
308. Today I have no vocal adnama, my
There
lord.
was a direction to
Next
file
week,
affidavits. Nobody
yes.
has filed affidavits.
Yes, I have seen the. There is a last occasion.
You're opposing the section 5.
I would not, my lord. I would not, my lord. Today I have no vocal adnama. That's why I am praying only, my lord. Next week. my lord.
Next Thursday.
Next Thursday.
Please see it is filed so that we can at least
Yes,
dispose of
yes.
the
I have
section.
seen, my lord. I have seen.
Unless Millard's restoration, section 5, then substitution, these are not allowed. The matter is
হয়ে যাবে।
otherwise ready for hearing.
হয়ে যাবে, করে দেব।
He says that he will not oppose.
Yes,
Let
yes.
us-
Yes.
On that day, we will dispose of him.
Yes.
Yes. Let him get his material consideration.
Well, this is my appeal.
In this matter, I am appealing for the respondent number
I am
6 and 7.
agreed with the Malad interim order of stay granted by the learned tribunal, thereby staying the Malad operation of the order passed by the concerned district land and land reforms officer. Last page of my petition,
Yeah, just give us
the order include.
Now, you were the applicants before the tribunal.
No,
You were not
private
the
respondents.
private respondents. So what did the appellate authority order was passed?
Yes.
Then why did he prefer?
Nothing. The appellate authority passed an order remanding the matter to the LRO to proceed afresh upon giving opportunity of hearing to all the interested parties.
Then he agreed by that he came to the
He came before
tribunal.
the learned tribunal. He took a point that there was no order at all on the basis of the reply furnished by the Block Land and Land Reforms Officer under Right to Information Act. The appeal was entertained by the appellate authority. That was not maintainable under Rule 29 of that West Bengal Land Reforms Rule 65. So, order is bad in law. That was the challenge before the tribunal.
Now, what is the problem? Now the tribunal has called for the main file to ascertain his allegation. And to stop the fact that appeal OA becomes infructuous, the appellate authority order has been stayed.
Yes.
How you are aggrieved?
But the appellate authority did not go into the merit of the matter. He just remanded the matter.
Tribunal is still in session.
Yes.
Tribunal will finally decide the matter on 29 January.
Yeah.
After the record comes and he scrutinizes the allegation of the appearance, that whether the appeal could have been filed on the basis of a report.
So that is the admitted fact. On the basis of the RTI report, the appeal was preferred.
Very good. So now the tribunal will adjudicate whether that appeal is maintainable or not against a
At the
communication.
same time, with my great respect to before your lordship, the application preferred by him, that was also not maintainable because he took a point that there was no order at all by passed by the concerned Block Land and Land Reforms Officer.
No,
That
we are unable to understand how you have been prejudiced. You have not been prejudiced. They are an interim stay because if it is not stayed, BLRO can file a fresh order on the basis of the order of demand.
Eviction was to start a fresh proceeding. Only this much order.
Now, if
And
the
even-
proceedings is started in the meantime,
No proceeding
during
because that has been
pendency
stayed.
of the original application, then he will not get his question answer.
They are
before
no
the-
way affected with the
by
order of the DL and
Again,
LR.
a stay is also not unlimited, it is limited till next date, and next date is on 29 January.
The
Till
present,
next date.
the present writ petition has been preferred. Needless to observe. Needless to observe. Mr. Mukherjee, needless to observe, the learned tribunal will dispose of the original application as expeditiously as possible without granting any unnecessary adjournment to either of the.
Both sides.
Yes.
Yes,
For the appellate, your lordship. My reply is already on record.
My lord, may I file the, my lord, opposition?
what is the order impugned?
Lordship, the order impugned says that
Page.
my memo of appeal.
I say, give us 2 minutes.
The last page of this impugned order, it records that the majority population in that particular village does not comprise of STs. But the census report that we have annexed in page 16, in page 16 and 17 of my stay application, it clearly shows that the majority of the population in that particular village comprises of ST. That is the only point to be concerned. And considered.
16 and 17.
16 and 17.
Now you did not get a, what happened? You participated?
I participated as a bona fide member of the ST. I have also annexed my ST certificate. I was not selected. Now the plea that
You
was
participated. So you got the opportunity to participate. So now his question is whether preference is to be given or not.
Right.
Preference for what?
preference for the ST candidate with respect to the village in case the majority of the population in that particular village comprises of members of STs.
So very good. Now what was the selection criteria? Participation in a test, written test.
Written test.
So you appeared in that. Now the results have been published.
Results published.
How many? One vacancy.
One vacancy.
Oh, the candidate who was appointed, what was his marks he obtained?
Marks.
And you obtained how much marks?
I obtained 37.8.
May I? His contention is not that he's the highest marks. His contention is that the preference should be given. May I just 2 minutes away? Under the tending condition, if the majority of the area is scheduled tribe or scheduled caste, then preference will be given to a scheduled caste candidate. Over here,
the preference in the same what?
In appointed as Asha worker.
No, if the person whom you have selected has obtained 50 marks.
No, that is a general candidate.
Oh,
that
that's
is not
general
candidate. So, but the point is majority of the people scheduled or not? That is the thing. Because
had there been a majority of scheduled tribe,
then she would have possibly been.
How? Even if she does not secure general category first marks of the first candidate.
Then the first scheduled tribe will be decided first, the first of the scheduled tribe candidates. There's reserve for that then. But the issue is, my issue is, Malad, if your lordship kindly comes to my affidavit in opposition, I have specifically provided.
So, Mr. Banerjee, why did you dig your own grave saying that preference will be given? What preference? It will be reserved for ST then?
If majority of the people are,
Then it is not reserved for
no,
ST.
if majority of the people are of scheduled tribe,
Hmm.
then preference will be given to the
Preference meaning what? That he will be
appointment. Yes.
Marks will not be the criteria. In that
Yeah, marks will not be the criteria.
the ST or the ST certificate.
So show us that criteria. That marks
But-
will not be the criteria.
Lordship, that has not been specified, but it has not been clarified also in the notification. Now they cannot go back by their own
Where is
notification.
the notification?
Notification is in page
Petition.
21 of the appeal.
Acha.
Now, what was the mode of selection? Taken.
Didn't
Oh, that
If,
is
my lord, if it comes to 5,
only yes, because there is no marking system.
No.
No written test.
Page 21.
21. Preference.
no, written test has to.
is there.
No, there.
Clause.
But this one is clause 5.
5
No,
and 7.
written test, which clause? The eligibility criteria is such and such. What is the procedure to select?
Lordship, there is no written test. It was only a viva voce.
Selection process.
No, that's the selection board because
Come to
everybody's
page
got marks.
Page 21.
Come to page.
It was lordship.
According to the marks obtained in Madhyamik or equivalent examination will be considered.
সেটাই clause
If lordship kindly
23.
takes my affidavit in opposition,
যা। এবার দেখো পেজ সিলেকশন will be based on marks scores in interview 10% হচ্ছে scores in interview
there's an interview, there's a evaluation of them, both. That's the score sheet.
সি এই পরের কথাটা এই পরের কথাটা
Selection was based on course in the interview.
10% ছিল তোমার জেনারেল ক্যাটাগরি আর এদের সঙ্গে
Yes, yes.
you participated in the interview
Lordship. If your lordship takes my page 21, your lordship see the score sheet of my opposition.
Then question of preference.
preference you have.
Preference will-
সেই জন্যই তো নম্বরটা জিজ্ঞেস করছি
Yes.
পেজ
21 of my affidavit in opposition.
হ্যাঁ you are Promila
Promila Hem.
Hembrun. And who has been selected,
Your
Mr.
lordship see this Moon Hari.
Moon Hari?
Your lordship see the last column aggregate score on 100 evaluation after taking a tally 52.99. Other is 33.05 and the other one my learned friends.
এ তাতেও হবে না you have scored lesser marks.
Lordship, the paramount factor is whether the member who has been selected is an ST or not. If the majority of the
Please
population.
come to your application. Please come to your application at page 23. The mode of the selection process. Got it? Page 23. Left hand side top, selection procedure. Selection will be based on marks obtained in Madhyamik. 90% will be for that and 10% will be for the interview. Now kindly come back to page 21 of the opposition. You scored Madhyamik. Your marks were 32.18. And in interview, you got 5.7. Now, the person who got selected, he got 44.49 in Madhyamik and 8.5 in interview. So his total is more than yours. Even if preference is granted, you do not come within the zone of consideration.
Then your lordship, what about point number 7? So that will not be the
Point number
7, page 21.
ও নিজেরাই ভুল করে দেয় কি? Page 21, point number 7. There is no 7, sir.
No, it's 5, not 7, 5. The 5.
Lordship, that is the eligibility criteria. First, the eligibility criteria has to
No,
be satisfied.
preference
then only-
will be, preference when can be given. Suppose you and myself, we are appearing in test. I am ST, you are general. If I obtained same marks as you have obtained, then the question preference will come. তাই না?
But your lordship, kindly
no,
look
no,
into
no.
the impugned order.
No, no,
It
suppose
has also decided categorically on the basis of the majority population. The impugned order, last paragraph.
we are with you. We are saying that they have not granted you preference. Even if we say that, how do you come within the zone?
That selection criteria, memo number
Keeping in
13 December 2021, cross 5.
that is page 25 এ আছে সেইটা 13 ডিসেম্বরটা
Page 25.
If lordship sees the top of page 26, that is there. Majority of the population, more than 50%, that is clarified by that.
No, you come to clause 5.
Yes.
In the, it is appearing subject to the confirmation, keeping the selection criteria fixed by the subdivisional level Asha selection committee within bracket memo such and such 13 December 2021.
3rd December.
3rd December. That means if it is found that in a particular in a particular area there is a majority of SC candidates, then
I have an
whether
answer.
a different
Your lordship, take my opposition once again.
Lordship, it
Your
is
lordship,
rather otherwise.
come on, but
If
your
there
lordship,
are two candidates
We are
from the
going to
ST
that.
and the
We are going to that.
if your lordship now,
I check all the things then.
now your lordship comes to page 27.
26 টা আগে প্রেফারেন্সটা লিখুন এটা
The sub-center area, total population,
yeah.
ST population, 47, less than 50.
যেটা আমরা বলছি না ইকুয়াল মার্কস পেলে তবেই প্রেফারেন্স পাবে তা নয় ইকুয়াল মার্ক পেলো কি কম নম্বর পেলো এসটি এসটি বেশি
Majority হচ্ছে more than
হ্যাঁ না এই যে যেটা আমরা বলছি না প্রেফারেন্স তখনই আসবে
3 yes, got it.
সেটাই তো বলছি
হ্যাঁ।
3 ক্লজ 3টা দেখ প্রেফারেন্স বলতে কি হলো ইন্টারপ্রেট হবে if ST having minimum requisite qualification meeting all eligible available then selection of the said position should be made from amongst them বুঝছো তো গুড়িয়ে গেল তো নিজেরাই ভুল করে
হ্যাঁ, তার মানে নয় ওইসব বাদ দেখা
ওই সময়
হবে না।
দেখা হবে
শুধু ওদের মধ্যেই হবে
হ্যাঁ।
ঠিকই বলছি You come to page 26, you cross.
Yes.
26 you dig your own grave further
In terms of preference, means if SC candidates having minimum requisition qualification and meeting all eligibility criteria are available, then selection of the said position should be, yes, if it is more than 50%.
yes
If the area is,
it is not area wise, village
but
wise.
please let me finish. 50% more. So therefore, now your lordship, if today your lordship comes to my affidavit opposition page 27,
27
He belongs to
this is area,
27 no page
affidavit opposition.
huh oh position sorry.
চলে যাচ্ছে village না
page 27 আচ্ছা
Yes, your lordship see sub-center, area, total population so and so, ST population so and so, percentage of population 47.33, is less than 50.
page 27
Yes.
area
top.
total
See,
Beria
this sub-center has these 5 villages,
47.33
47.33. So it's less than 50%. So when, so these preference,
come back to you
this preference will not be apply over here because it is 47.33 and it has to be more than 50%.
Lordship will kindly comes to page 20.
If today it had
20
exceeded,
of my appeal.
We will come back to you, sir.
We are
We are not
all-
throwing you
all-
out.
today if
We are giving him trouble.
yes, I am the one on the receiving end. My landman should happily keep quiet. So basically what I'm saying is,
No, what makes you feel that you are in the receiving?
I am always in the receiving end. Not now, for many years. No, I'm not complaining about that. I'm proud recipient of your lordship's affection. But coming back to the matter. Today, as far as the sub-center area is concerned, the total population is 3980 on the top. Then is ST population is 1884. Percentage of ST population is 47.33. So this
They
thing,
do not come.
this preference is more than 50%. Then it would
Only
be
preference.
I would be stuck under, if this is more than 50%, then the next, then it will be limited to only scheduled
And
castes.
what is your answer to his
Lordship will
contention
kindly
that
comes to
central government
Page
says
20. Page 20 of my appeal.
20 of the
The appeal.
application?
Stay application.
20.
20 of this day.
What stay
It's a whose where from you have got this annexure? Annexure, this is to subdivisional officer by the CMOH Health. What you are showing, sir?
My stay application, your lordship.
Yes, page 20.
Lordship, it is Bedia is the sub-center.
Yes.
Village is Polash Pahadi. Vacancy arose with respect to the particular village. And as per the census report, the population in that particular concerned village is showing a majority of ST population.
Where do we find that?
Lordship will kindly comes to page 10 and 11 of my appeal, of my stay application. Stay application out of 16 and 17, sorry, your lordship. 16 and 17 of my stay application. This is the census report as of 2024.
Yes, where you are showing in Polash Pahadi village. Center is
Scheduled
at
tribe 146. And page 17, your lordship, the percentage. That's 60.33%.
no, show us the advertisement that Polash Pahadi, it is from not for Beria, it is Polash Pahadi. Beria is the sub-center including many villages.
Five villages.
Five
Lordship,
villages.
page 20. That's page 20. Page 20 of my stay application.
Yes. Name of the sub-center is Beria.
Bedia. Village Polash Pahadi.
Maybe.
Kindly comes to page 21.
No, page
Clause
21.
5. Area means village, not sub-center.
No, area definition there.
Point number 2, should be a resident of the same area village.
Where is annexure C to that? Where is annexure C as referred to in clause 2?
Town area.
Annexure C column 4. Where is that? Area. This kindly come to page 23, bottom annexure C. Area wise, a Asha vacancy under different health sub-centers.
Yes.
So the Asha vacancy is pertaining to the sub-center.
No, village. Point number 2 has clarified that area will mean village, not sub-center. Point number
It is within bracket village. It is within, now should be resident of same area bracket village, which will be selected as mentioned in annexure C.
Yes.
Now kindly come to
Then-
page 23 bottom now.
19. 19, page 20. Page 20 application for
Villages has not
C1 to C4.
C2 বলছে।
এটা C2 বলছে।
কিন্তু এটা C
ব্লক ওয়াইজ আসা ভ্যাকেন্সি।
টোটাল ভ্যাকেন্সি হচ্ছে নেম অফ ভ্যাকেন্সি, এটা হচ্ছে নেম অফ ব্লক হচ্ছে শান্তির, নেম অফ
Lordship, page 20 is C2,
হচ্ছে
annexure C2.
কোর্সিকা, নেম অফ সাব সেন্টার হচ্ছে বেরিয়া, পেজ হচ্ছে পলাশ পাহাড়ি। যদি যখন রেসিডেন্স হবে আমি করেছি সিঙ্গল।
কেননা বেরিয়াতে আর কোনো, কিন্তু সাব সেন্টারে আর কোনো ভিলেজ নেই। সাব সেন্টারে একটাই ভিলেজ পলাশ পাহাড়ি।
মিস্টার ব্যানার্জি,
Annexure C starts from page 18 of my.
পলাশ পাহাড়ি village, area means village and Palace Pahari village, and comes to page 20 of their application. Their vacancy was declared in respect of block হচ্ছে Santuri, Kam Panchayat Gorsika, name of sub-center area, name of village Palash Pahari, number of vacancy 1.
Polashpari is the place where the Beria sub-center, that village, but it caters to 5 other villages.
Which are those 5 villages?
You see my, your lordship sees my chart, page 27.
বেরিয়া, গোয়াল বেরিয়া,
Polashpahari, Matindra, and Kulai.
এখানে নেম অফ ভিলেজ দিয়েছে।
এখানে
It's there in page
So
20.
if your lordship sees that,
number of Kam Panchayat, number of sub-center barrier population হচ্ছে পলাশ পাহাড়ি হচ্ছে ST,
is one of the villages. So total area, this is,
yes,
No, it is only one
of
village.
পলাশ পাহাড়ি
there is majority.
of total population 298 and scheduled type population 1110. So it is not more than
No, no,
That is also not more than 50%.
50%. You come to page 27 of their
it has
affidavit
no
of
basis. What I am showing is the census report.
But what is
They
the
have
authenticity of that
calculated their
census report?
population according to their own convenience.
But this is my report.
The census report has not been prepared by the appellate.
Census report, what is the authenticity of this census? This is not the census
is there
report.
by the government of
What is,
India.
it is not part of the census.
16 and 17 years.
That is not census
of my,
report.
stay application.
That is not the census report. This is the extract from some document, not a census
We have
report.
derived that from the website of the central government.
Where is that you showed us?
Page
Census?
16 and 17 of my stay application. Your Lordship.
Mr. Banerjee, who has prepared this chart which you have annexed?
My officer, has done it. I'll tell you, this has come from the subdivisional officer,
medical office.
subdivisional officer, SDO.
Lordship, my census report tallies with the voter list of that particular village. If your Lordship desires, directs, I can produce the voter list of that particular village also.
So you have to tell us how this ascertainment is made by the state from the central census
Exactly.
report, or you are adopting?
I am, that I can take instruction for what is the source, because
No,
this
have
has
you
come with
replied
under
to-
the,
replied to that census in your opposition?
No.
no,
Have you dealt with that, Mr. Banerjee?
paragraph is deal করেছে।
I've been করেছি তো অবশ্যই। Census paragraph কোনটা?
No, sub-center includes 5 villages, you are saying. Now the sub-center, your selection is only, it's confusing, na? Your notice for engagement says sub-center at the first paragraph. Sub-centers in annexure C.
Sub-center Beria.
Sub-center is Bedi.
Beria.
Under Garsi.
Under that sub-center, Polar.
One of the villages is Polar.
Polar.
This particular vacancy was with respect to
Beria total করে দিয়েছে। বেরিয়া টোটাল করেছে, ইন্ডিভিজুয়াল ভিলেজেস এরও করেছে।
হ্যাঁ, ইন্ডিভিজুয়াল ভিলেজেস করেছে।
এই যে গোয়াল বেরিয়াটা দেখি, গোয়াল বেরিয়াটাতে
টোটাল পপুলেশন 242 এর মধ্যে শিডিউল টাইপ আছে 146 আর এ বলছে 142। এই ফিগার গুলো মিলছে।
Authenticity of the document.
So, Your Lordship, I can produce the electoral roll and the election
roll. Who will count? Whether court will count.
It tallies with the census report.
That was not your case before the writ court also. Now you have in appeal taken all these points.
And I've given the figures and facts and figures over here.
And kindly come to page 27 of your application. Of their opposition. They are saying in Gwalberia te more than 50%.
More than 50%.
But Gwalberia does not come within Santuri block. From your application page 20, where do we find Gwalberia, Mr. Man? গোয়ালবেরিয়া পাওয়া যাচ্ছে না, মাটির ডুন্ড্রা প্লাস ডালান বোর্ড এগুলো একটাও এখানে আসছে না।
ভ্যাকেন্সি স্টেটমেন্টে
এই যে লিস্টটা দিয়েছে 27 এ, এটার সাথে ভ্যাকেন্সি স্টেটমেন্ট।
গোয়ালবেরিয়া ডাজ ইট কাম ইন? গোয়ালবেরিয়া এর মধ্যে নেই, অন্য কোন জায়গা বলে দিচ্ছে।
গোয়ালবেরিয়া লেখা রয়েছে চোখের সামনে, দেখো কথা বলছো।
No, Mr. Banerjee, where from we will find sub-center Beria consists of 5 villages.
That
because their application page 20, that is your annexure C2, your vacancy is against block Santuri.
If Your Lordship kindly comes to page 18 once of my opposition.
Asha vacancies under different blocks. Raghunathpur subdivision.
Page 15, name of the block Santuri.
So in Raghunathpur subdivision, there are 1, 2, 3 blocks. And in respect of all the villages of the respective blocks, there is 1 vacancy each.
কোর্সিকার মধ্যে আছে বেরিয়া।
So when
if my lord kindly comes to page 18, Your Lordship will see of my opposition, Your Lordship. The term area is to be interpreted as demarcated service area assigned to a vacant position for which the selection process has been initiated. This is the demarcated portion. So my submission, my lord, before Your Lordship is
page 80.
Page 18.
Demarcated service area assigned to a vacant position for which the selection process is initiated, right?
So, my lord, today my submission is that as far as the sub-center at Beria is concerned, this is to cater to 5 villages. Now, these 5 villages, 1, 2, 3, 4, I have given. I have given the population of each one of them.
So, you show us that in the other 5 villages, Ledersan, Santuri, Muradi, Musulia, because you see your chart C2, you are saying 5 villages, but for the respective villages, there are separate vacancy. For yes. Kindly see C2, page 20 of their application.
2 vacancies, Your Lord.
For the first one, Gram Panchayat Tarabadi, name of sub-center is Ledason, composing of village Muraldi. Muraldi is 1 vacancy. So for the subcenter at Ledasan, only one village is there. Similarly, for subcenter at Bedia, only one village is there.
But with my instructions are contrary. This is this particular, because this Palash Pahiri is one of the villages.
Not one. It is the village
Only village.
in respect of the subcenter Bedia.
No, with great respect, no.
One and only village, your lordship.
My instruction is that no, as far as if your lordship sees page thing, it is, if your lordship sees in name of block Santuri, all this comes under Santuri. Then your lordship say Gram Panchayat, Goris.
In Santuri, there are 7 Gram Panchayat, 7 subcenter, and 7 villages.
Yes.
So for the Gram Panchayat Godalika, subcenter is Bedia, and the only village is Polashpahad.
This is where my instructions are contrary. My instructions are that as far as this particular thing, if your lordship sees page 27, lordship find this particular subcenter is 1, 2, 3, 4, 5 villages are covered by this. This is the demarcated area.
Yes, now the question comes, area means whether any particular village area is to
No,
be
the demarcated area.
or area is to be
The demarcated area.
Demarcated service area.
Yes. So demarcated service area is 5. And
No,
when
5 villages.
5 villages.
Demarcated service area is annexure C2,
Exactly.
which they have annexed
It is
at
part
page
and
20.
parcel of
No, this is at village.
No, not page 20 of the application, their application.
Yes.
There you see Santuri has 7. There are 1, 2, 3, 4, 5, 6 Gram Panchayat. And in respect of each Gram Panchayat, there is one subcenter. So in respect of Gram Panchayat Godalika, there is only one subcenter Bedia. And that subcenter pertains to Polashpahad.
With greatest respect, no, my lord.
You know?
This may be situated at Polashpara, but this area it is catering to is all these 5. All these 5.
You show us that line, that all this.
Then I can put in as affidavit and bring that clarification before your lordship. Because my specific instruction is that it requires, it is service area is all 5 villages. If it is taken all 5 villages, the total population comes to is 47.33, which is less than 50%. That is why a general candidate was taken. If it would have exceeded 50, it would have been a scheduled caste, scheduled tribe candidate.
No, Mr. Banerjee, we have other dispute come to should be resident of the same area and village.
Yes. So even if today I take Polashpahad,
when a candidate offer her candidature, his her Asha, then he should be resident of Polaspur village.
because that is where it is situated.
So, so you are giving meaning of the area and village in respect of eligibility criteria to a particular village.
Exactly.
But when you are trying to ascertain whether the majority would be scheduled caste, then you are taking the
Yes.
5 villages.
I'm telling you, now may I come? Today, this particular subcenter is located at a village called Polashpahari. That is why today the staff has to be from that village because they have to cater.
No, subcenter is Bedia.
Bedia, but it is in Polashpahari. That is
Subcenter is at Polashpahad.
yes. Bedia is the
Its name is subcenter Bedia.
subcenter Bedia, but
It is
situated at
situated
Polashpahari.
at Polashpahad.
Polashpahari, which it is covering a distance of 5 villages.
No, then how can you say that? Then what? How will be your calculation in respect of Ledasan then?
Huh?
Modal, kindly come to first one.
No, we are not got into the figures of the first one. We are on now. If your lordship says, I won't.
We are saying in your like Bedia, there is another subcenter Ledasan situated in the village Modaldi.
Yes.
So you are saying that when in respect of each of them, the total population in Bedia has to be taken into consideration.
No. Total, your lordship, this is in Santuri.
In Beria, how many villages are there? Tell us.
Beria, that's what I said. Beria, it is 5 villages.
Where do we find that?
That is my chart.
Page 27.
This
That is
chart
page 27. That is my chart.
Beria is 5 villages means total Pulia,
One is Beria, one is Goal Beria, one is Polash Pahadi, one is Matinder Swansu, and one is Kulai.
Lordship, there may be 5 villages, but
wait. Ia Goal Beria এখানে আছে কি? মুডুলিয়া না ঠিকই বলছে কেমন এটা দেখো বেরিয়াতে তো বলছে বেরিয়াতে এই সাব সেন্টার জন্য 5টা নেম অফ দি ভিলেজ বেরিয়া এই যে সাব সেন্টার হচ্ছে বেরিয়াতে 5টা শতাংশ বলছে আমি 4 এবার তুমি সেটাও আসো এই 5টার নাম কিন্তু এই গোয়ালবেড়িয়া পলাশ পাহাড়ি এই যে গোয়াল এই নয় যে প্রত্যেকটা জায়গার জন্য একটা সাব সেন্টার আছে এই দেখো গোয়ালবেড়িয়া যেমন এই লিস্টটাতে গোয়ালবেড়িয়া নেই
না নেম অফ দ্য সাব সেন্টার হচ্ছে বেরিয়া আমার মনে হয়
এবার এই
সাব সেন্টার হচ্ছে শান্তুরি
না
No, that's in the block.
block. Shanturi is the block. And name of the sub-center Beria. Name of the village, Polas.
Because that sub-center is situated at Polash.
Yes. And it is catering to 5 villages.
Because maybe the office or place of functioning is located at any place at Beria. But the man is being engaged to work for Polas Pahari village.
Because it is situated there, so it has to be a local person from there.
Lordship, the vacancy was with relation to that particular village only.
No.
There may be 10 villages, 20 villages, but the vacancy was with respect to that particular village, Polash Pahadi. That is how the notification has been given. Residents of other village cannot be entertained in that particular village.
Even in Polash Pahari, the majority is not. And if your lordship sees, even if my learned friend's case, even in Polash Pahari, the majority is not scheduled tribe.
It is your lordship.
It is. They are saying that their population is 146 out of 200 something.
No, that is not correct. That is not correct. I am disputing that. That is not correct.
Page 70.
That is not correct. I am giving the figures of Polash Pahari village also.
Because none has put his signature, none has taken responsibility.
No, I have done it. In my affidavit, it is there. This is part of the affidavit. This is the affidavit affirmed by Deputy Magistrate and Deputy Collector.
Who is the selected candidate? Who is the selected
The general, I showed you lordship.
respondent here?
That Hari. If your lordship comes back to
Let the
page 21.
Then you bring in a supplementary affidavit showing your population electoral roll and everything.
Electoral roll only the voters.
That tallies to the number of
Population.
Population.
Electoral roll is not all of your lordship is ungrateful.
Even the population which they have got doesn't match the census report and the electoral roll.
Who have not been voters, actually, they are also.
Then he has to produce the affidavit by the census authorities. That what is the authenticity of that report which is annexed. Your lordship will sitting in the report, would your lordship get into this exercise? I do not know. Then your lordship will have to call for the government of India officials.
Data of the census report.
Sir, you have to justify that. That was not your case before the
In
report.
that
First,
case,
number
lordship
one.
may direct
No, 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 no. This way there cannot be a roving inquiry into. We are in judicial review. You have to pinpoint us. So it is not a case just for the sake of litigation will continue. Because the verdict which you are wanting would be disturbing the entire selection process of Asha. Hue and cry will be raised. So many persons appointed.
notification.
You participated in the selection process.
Lordship, if the notification itself is inconsistent with their own records.
Mr. Ghosh, learned advocate appearing for the appellant, press for leave to file a supplementary.
demarcated service area. Ultimately, we reach to
That is why we have to.
to this
Absolutely, absolutely. I'm bound on to it. Because if it is village, if it is Polash Pahari, my figures show it is not. Even then, no. But then the issue is whether the census report is to be considered by your lordship or not. Then that comes into it.
Yes.
সেন্সাসটা ক্যাটেগরিক্যালি ডিনাই করা
জানি রিপ্লাইটা দেখেছো? পড়াশোনা করো তারপরে কথা বলবো।
Thank you, Mr. Banerjee. Yes, Mr. Ghosh. When Mr. Banerjee is there, he will come up with that instruction. When Mr. Banerjee is there, in other matters we have seen that the right information has been placed before us. So you need not worry, you are in safe hands.
I'm for the appellants.
Lordship, I beg to appear on behalf of the respondents in this matter.
The affidavit of service.
Yes.
There are 17 days delays in my applications. One of the petitioners was selected for constable in the Railway Protection Force in 2033. Thereafter, the petitioner appellant was fit for medical fit, and thereafter he sent to the Gorakhpur for initial training. And thereafter, my lord, after training, he was declared as discharged because the appellant was failed in 3 subjects.
Wrong information given in the.
No, he did not pass the written test.
To qualify in written.
He did not pass the written test. Thereafter, the petitioners moved the writ application. The first writ application, minors kindly come to page. The first round writ petitions, minors, page 52. Page 52, lordships.
Page 52 of the.
My application. My stay application. This is the first order dated 18 August 2015.
Yes.
I'm reading it. Mr. Mojumdar, learned advocate appearing on behalf of the petitioner, submits that his clients are similarly placed with the petitioner number such and such, which was disposed of by an order dated 5th August 2015. This is the next matter, lordship. And the first petitioner in this case that he had failed in 4 subject and
there are 5 matters.
2 matters, 1 and 2.
That is
6 and 7, the similar matters.
You are appearing
in both the matters. My lord, initially there were 5 matters on same cause of action, my lord. But in appeal, only 2 have come, my lord.
Oh, I see.
We have not preferred appeal against
3 persons have come. 3 persons have come.
3 persons have come, and rest have not preferred appeal, my lord.
The first petitioners in that case had failed in 4 subjects, and the second petitioner in 3 subjects seeking to qualify for being appointed as constables in the Railway Protection Force. Mr. Das, learned advocate appearing on behalf of the Union of India, submits that the petitioners were not allowed second attempt as per Rule 64 subclause 3 as it stood in the year 23-4. According to him, the petitioners having failed to 3 subjects more, there was no questions of granting them second attempt under the Dedin rule, which allowed her second attempt to a candidate who had failed inter alia in 2 subjects by a maximum of 5 marks in each subject. Be that as it may, this court neither in the earlier order dated 5th August 2015 nor there hereby makes any finding or observation providing regarding denial of second attempt to the petitioner in this case. Lordship, in this respect, Lordship, I would like to
read the letter.
They are not allowed to take second attempt by applying the provisions of then rule. However, as in case, so in this case, the respondent authorities might consider the claim of the petitioner for taking second attempt in passing those subjects, provided the respondent authorities and that the petitioners made the criteria specified by the Director General of this Chief Secretary in the matter of allowing second attempt to the petitioners under the said amended substituted rules. Rule 64
when did you
amended in 2013.
When was the written test?
Written test was in the 2004.
2004 written test.
And Lordship,
wait. In written test was in 2004. At that time, which rule was in operation? The rule that was in operation did not give a second attempt.
Lordship.
Now they brought in a new rule
30,
by a gazette notification in 2013.
And
making provision for
not-
second attempt.
second attempt. And
So this, how can you apply this, that in amended provision?
Lordship, this order, Lordship, that the first order, Lordship, kindly have the judicial note.
Yes, page
Lordship, have
55 is there.
given, opportunities to, Lordship, kindly have.
No, no, after that order, which you showed us, they passed an order. Page 55.
Yes, they passed an order, Lordship, page 55.
Right. There you kindly come to the fourth penultimate paragraph. These rules have now been amended.
Lordship.
Published in the notification 16th August 2013.
13.
These have no retrospective effect.
Lordship, in certain case, Lordship, there is substantive right is not affected. Lordship, I would like to satisfy, Lordship, kindly give a date. I'll try to satisfy myself.
How
Lordship.
can you satisfy?
Lordship, in view of this, Lordship,
Rulta was not even born on the date when you applied. Not even you filed the writ petition in 2005.
Lordship, kindly kindly consider the order.
And you kept the writ petition pending for 10 years.
Lordship,
তারপরে 2015 disposed.
Lordship, I did not keep in pending. This automatically this writ petition has come up.
How it can happen, sir? Suppose my client will be facing some problem. I will file a writ petition, advocate will not take steps. Some mentioning, some application, something to be done. Because you know that with the passage of time, your client will also become old.
No.
And the court will also be reluctant.
Yes, Lordship, I am not taking any benefit the amended rule. But
Then-
now, fortunately, the rule has been amended. A lot of, in view of that, Lordship, the first order, your Lordship, kindly please, the first order, Justice Sina has given me an opportunity to consider.
Yes, they have considered. Considered and an order was passed in the year.
No, no, in view of that amended rule, they have, the Justice Sina has been, Lordship has been considered to comply.
Where is that? No,
Lordship,
no.
kindly, be that as it may.
Mr. Das, advocate of union, they were not allowed second attempt as per 64.3, which stood in 2003,
Kindly
2000.
come the second paragraph. Be that as it may.
Be that as it may means I am not considering. You
Lord-
make a representation, let them go.
No,
Now,
Lordship,
what did the trial judge say?
Lordship, second paragraph, the trial court, this is the offended. Lordship, I'm coming. Be that as it may, this court neither in this earlier order dated such and such nor hereby makes any finding or observation regarding denial or second attempt to the petition in this case, they were not allowed to take second attempt by applying the provision of the present rule. However, as in that case, so in this case, the respondent authors might consider the claim of the petitioner for taking second attempt. Lordship, his Lordship has given me an opportunity to consider. That has not been considered. The second, Lordship, the second line. However, in that case, so in this case, the responding authors might consider. This order was passed, Lordship, after amendment on 18 August 2015.
Now, whether they have considered this order as
No, that they have not
has
considered.
given effect to.
They have not.
No, my lord. Kindly takes page 55, my lord. Kindly takes page 55.
Okay.
Sorry, page 54, my lord. Annexure P3 of their application, my lord. Page 54, operative order is at page 55, my lord.
They have rejected.
My lord, there is no rules are there allowing us to give retrospective effect, my lord. 2003, my lord, my learned friend, in a nutshell, my lord, what is the fact of the case? 2003, my lord, they were recruited, my lord. My lord, they failed in 2004, my lord. Now, these rules of giving second attempt, that was in 2013, my lord. After 10 years of, almost after 10 years of them, we are recruited, my lord. Now, they are claiming that since they failed in 2004, rules got amended in 2013, my lord. After 9 years, my lord. Now, they are seeking, what they are seeking is a retrospective effect of the amended rules, my lord. After that, also after passing of 9 years, my lord. And our amended rules does not give any scope for giving retrospective effect of, my lord, of the same.
Only on that aspect, Lordship,
If
whether
my
this
lord,
rule
if my lord
can be
kindly takes the
applicable.
impugned order passed by honorable single judge, my lord, it's a detailed order, my lord. Everything was considered, my lord. My lord, since I was there, my lord, since I know the matter, my lord, I have not gone through the appeal, but since I was appearing before honorable single judge, my lord, kindly takes, my lord, in details, my lord, every provision has been, my lord, dealt with by lord, honorable single judge, my lord. It's a detailed order, my lord. Yes, 16.
ইয়ে করে ডিসমিস না করে রাখতে পারি করে দিই না Mr. Mishra, what is that
my lord,
the order of the learned single judge? They raised allegation about some persons who did not pass.
No, 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 my lord. That was also dealt with. That was on altogether on different footings, my lord. Altogether on different footings. That does not match with this case, my lord. That together they try to substantiate, my lord, but that was also dealt with, my lord. That was altogether on different footing, my lord. This has
whatever it,
nothing.
Lordship, they have given
Nothing
a
to
second
do with
chance.
the present case, my lord. Nothing to do.
Whatever it, but they were given an opportunity to sit in second attempt. This is, Lordship, might the second ground. Lordship, kindly give a one date so that I can.
There is nothing, sir. Sorry to say.
Really,
The present appeal has been preferred, challenging an order dated 2nd August 2024, passed by
Item 8, my lord, I am appealing for the appellant. This is my affidavit of service, my lord. All are served. My lord, in the read petition, my lord, I have challenged.
Give us 2 minutes, please.
My lord, my lord.
Yes. What is the stage of the disciplinary proceeding now?
Lord, I do not know because it's almost over 1 month, my lord. I have filed my reply to the charge sheet. Now, the charge sheet, my lord, has been served on me on 91st day at 1:20 a.m. at night. They are following CCS. Now, my lord, as per CCS, they are duty bound to serve me with the charge sheet within 90 days. 4th September, my lord, I got suspended. Time 90 days expired on 2nd December. On 2nd December at night, that is, my lord, 3rd December at 1:20 a.m. Page 120 kindly sees the track report because they have posted the article with my phone number, so it was easier for me to track the consignment. Page 120. First, my lord, page 119. This is the SMS that I have got from the Department of Post.
You're working at Guwahati?
Right now, my lord, till suspension. I was at Guwahati since January 2023.
Till December 2022, I was at Chennai. Since 2015 February. They sought for my choice of my transfer. I have given two names, Kolkata and Mumbai. And they have transferred me to Guwahati. Still I work there. I have two difficulties at home. My mother is a patient of bipolar disorder and my wife is a cancer survivor.
So why your suspension order was issued?
Kindly see the suspension order. Then I will show you, Lordship, that is recorded in the, my submission has
So
been
where
recorded
is
in
the
the
writ petition?
writ petition.
You have
Milord.
annexed.
Writ petition is not annexed, but Milord, the annexers are there.
The prayer of the writ petition.
Prayer of the writ petition, first prayer was Milord to Milord revoke the suspension, and second was Milord tertiary, that is to transfer me to Kolkata. Milord, I'm sorry, Milord, I can hand over a copy.
No, show us the suspension order then.
Yes, suspension order, Milord, is at page 59B. Whereas a disciplinary proceeding against Diptendu Das, field assistant presently posted at northeastern zone of RRRLF in Guwahati is contemplated. Now, therefore, the undersigned in exercise of the powers conferred by Sub-Rule 1 of Rule 10 of Central Civil Services Classification, Control and Appeal Rules 1965 hereby places the said Sri Diptendu Das under suspension with immediate effect. Now, my lord, kindly see the last paragraph. Why I got suspended? The circumstances in which, page 59B, the circumstances in which the order of suspension is made are as follows. Sri Diptendu Das, field assistant RRRLF, has been found prima facie guilty of submitting false and fabricated true reports with forged photographs, purported to have visited some libraries and claimed TA by submitting fake TA bills for such visits. It also been found that in one of the said visits, he has produced an e-boarding pass downloaded by him from the website of an airlines without any journey in the said boarding pass and claimed the TA. These lapses on the part of Sri Das are very serious in nature and amount to grave misconduct. Now, my lord, kindly sees the charge sheet, how it deviates. Charge sheet is at page, my lord, 72. They are saying I have not
interim order you want. There is no scope for any.
There is no scope for any interim order, but my lord, as per 2015 Supreme Court judgment, my lord, if the suspension, if the charge sheet is not filed within 90 days, my lord, the employee cannot be kept under suspension. If the employer wants to keep him under suspension, my lord, the employer must come up with a reasoned order. Now here, my lord, after 4th September, there is no fresh suspension order, and 9th December, I have posted my reply to the charge sheet.
90 days after the writ petition was disposed of, 90 days was over.
Before the...
Why didn't you take that point in the writ?
I took that point.
Where is it?
My lord, kindly see the order, charge sheet.
The single judge did not consider this issue.
I try to impress upon the single judge that kindly, since I have already affirmed on supplementary affidavit, kindly give me an opportunity to file the charge sheet as well as the reply to the charge sheet. Because 16th December, my lord, the matter was moved. And 3rd December, I got the, my lord, copy of the
Have
charge
you
sheet.
annexed that here? Have you annexed your supplementary affidavit here?
The documents I have annexed, my lord.
Yes, yes, sir.
So, my lord,
how can you keep him under suspension after
Your
90
lawful
days?
is a pair made before the trial court. Only order of suspension.
Right.
Your lawful is the pair.
No. You considered this, that how your suspension.
That point has not been taken in the writ application trial court, my lord. The order of suspension was challenged That is, in contemplation of the departmental proceeding, suspension was made. My learned friend argued before the trial court, my lord. This is in terms of the CCA rules 1967, my lord, that is not applicable in this case. But I have, my lord, submitted the document.
No, right, we are on that. Mr.
That is
We are
what?
wanting to know after 90 days how you could have done so.
Your lordship knows the suspension can be revisited. Or order of suspension can be revisited on the prayer of the applicant or the suspended employee.
No, unless the rule provides that if it is not within 90 days, the suspension goes.
Will we go by? That will go by.
Then how
But
do you answer
no,
that?
my lord, that part, my lord, the charge sheet, as and where the charge sheet, that has not been annexed, and that point has not been taken to the writ application. Your lordship can see.
No, this writ petition was disposed on 16 December. Yes, you are right that he has not argued this point.
Yes,
I
and no argument,
in the order.
no prayer, no grounds.
Recorded in the order that after filing the writ petition and after affirming the supplementary affidavit.
Have you taken 90 days point? Yes or no?
I have taken that
Where
point.
is it? In the
That
order?
is not there. That is why I am before your lordship. I have taken that point specifically that on 91st day at 1:28.
Where, sir, you have stated that?
Lord,
where have you stated that records at that time were not?
Absolutely, Miller. That's why I prayed before his lordship that give me an opportunity to file a additional supplementary affidavit, because supplementary affidavit has already been Miller affirmed. That is the reason. But no opportunity has been given to me to bring those documents on record.
Rule 10, you showed Rule 10.
CCS Rule 10, Miller, that is there. I don't have the book right now,
Yes,
Miller.
I have got
this suspension is as per Rule 10. Now, Miller, my learned friend,
you are arguing a point without the rules.
No, Miller, it is not
you
in the
are
library.
shouting so much that 90 days, 90, you have to consider, you don't have the rules.
No, it is not in the library. I went there. Miller, it is not in the library.
Suspension order dated 4th September 2024.
Yes.
Charge sheet order dated,
3rd December.
2nd December.
2nd December night at 1:20 am. So, Miller, it's 3rd December. After 12, it's 3rd. Kindly see the track report, page 120.
90 days expire on
2nd December. And 2nd December at night, that is Miller 3rd December, 1:20 am. They are posting the document. And 3rd December.
Where is that document? Charge sheet document posted.
Charge sheet, Miller, document posted. Page 120. That is the track report. 119, page 119 is the SMS that I have received from Postal Department, where, Miller, the consignment number is there. And kindly see page 120. Item book 112. At night, and this particular post office remains open for 24 hours. That's why they went there. Kindly see at 112, it was booked. My Rabindranagar sub post office, Miller, they have received it at.
Where in the charge sheet you have taken that point that it was issued after 90 days? That point is also not there in your
That point is not there, but I have only, Miller, elaborated the points.
The charge against you is very serious. And if you are this is a point taken by the arguing counsel now. This is not the point which your client took even while replying to the charge sheet. Not. So why do you ask us to interfere at this stage? Who is going to calculate this and say? These are disputed questions. How can we help you?
Miller, if your lordship kindly
show us the line in the charge sheet reply. You participated. You ought to have taken that point.
Miller, I was directed to give a reply. I gave the reply. Miller, I cannot.
Is that
Miller, I cannot disobey them.
Where is that reply?
Reply is at page 121, Miller.
Yes. 121, nowhere it is stated that
yes, on December 2, first page. On December 2, 2024, at about 10:59 p.m., I have received one email from your office in which a surreptitious charge sheet has been sent to me. Surprisingly, hard copy of the said charge sheet has been booked in a post office at 1:12 a.m. on December 3, 2024, which creates doubt about your conduct. So, my lord, the date and time that is I have mentioned, my lord. Mail, my lord, will not do because I am served with the suspension order personally. I am supposed to, my lord, serve with the charge sheet either personally or by post. I will go by the post. This point has I have taken. The time, the date, everything I have taken. They have not, my lord, given any reply to it. What they say, I remain absent in my office for 1.5 years, but my lord, they have paid me. I have, my lord, in my reply, I have given all the my salary slips and my bank statements. Second thing, my lord, they have said I have not gone to Nagaland. Now, my lord, there is a circular in my office.
When did you, when was the transfer order issued? You were suspended when you were in Guwahati.
Yes.
Now-
Transfer order in mirror 2022.
To Guwahati.
To go to Guwahati.
Now they have issued any fresh transfer order?
No.
They have not issued
No.
any fresh.
On the date of my suspension, my lord, I was at Guwahati. I received my suspension order at Guwahati. Technically, I am now at Guwahati. My lord, kindly considers this judgment. My lord, kindly sees this, considers this judgment. 2015.
Sorry,
What will be the purpose in keeping him under suspension?
Lord, your lordship, only
He will work in Guwahati.
I will go.
You are holding disciplinary proceeding.
departmental proceeding in contemplation, suspension in contemplation, the department. Only one word.
Mr. Niyogi, what purpose will be served by the employer by keeping him under suspension? Tell me. Suspension. For what? That he will be tampering with the evidence, or he would be misleading the.
For conducting the department of in contemplation, your suspension. First word, my lord, started, my lord.
No, understand.
Yes, your lordship knows that part. I am not arguing. The suspension placed under suspension in contemplation of the departmental proceeding. The
That
department.
is right. That is right. I am asking you that what part you are paying him subsistence allowance?
No,
He is
I'm not receiving. That is what.
He's sitting at home. He's enjoying his salary. What purpose will be served? Take instruction and come back to us.
Yes,
you allow him to join. He will not join at Guwahati. This will be the problem.
I'm the only field assistant at Guwahati. Right now, no work is being done because all the works are being done by the field assistants. Field officers do not go to the libraries.
Mr. Niyogi, you.
Nondi.
Oh, sorry, Mr. Nondi. This. You apprise us that what is the requirement
to keep under suspension.
For
That
even
part.
after 90 days.
Yes.
What is the requirement?
After 90 days, my lord, that is the.
You tell us that you keep him under these conditions. We will incorporate all those conditions.
Only.
He will not make any attempt or venture to influence any of the witnesses.
But rule never says, my lord, to keep the suspension, not to be kept in suspension beyond the 91 days. That is a judgment by that rule.
We are not. We will consider that. We are not going into it today.
Yes, I'm taking that part. Why? What is the necessity to keep the?
Then you will make your argument. We will finish off the case.
Where in Rule 10 it has been provided for that immediately after 90 days order of suspension will go.
Yes. Supreme Court judgment is saying, my lord, if within
rule.
A judgment will coming later. Rule.
In the rule, my lord, I will bring the rule.
Rule I have brought.
You show us that analogous provision is there.
Definitely. Supreme Court judgment is very clear on
Are forget about judgment. You are basing on rules.
rules.
Bring the proper rules and
Difficult.
Party learned
We are not
appearing
within
for
the jurisdiction of CAT.
I have not argued that
You are
point.
coming to argue and
I'm not
matter.
going into that.
I am not argued
I'm
that
not
point.
going into that.
Administration learned
You-
advocate
You
appearing
take
for the
instruction
appellant.
over there. You will
Mr.
take 75%
Nondi learned
without
advocate
doing any job.
And he is reluctant to
Milord,
receive
let's-
the
appearing
substance.
for
That
the
Let me
he is
clear one
not
thing,
interested to accept the.
No, no.
is directed, lease team, heard Mr. Sachin for the appellant, lease the matter for further consideration on 21st January.
কবে কবে?
21
Mr. Nondi learned advocate appearing for the respondents is directed to avail necessary instruction in the meantime.
Yes. In the last occasion, Millard, Lordship was pleased to direct us to produce some of the document, Millard, indicating that whether the scheme still in force or not. Millard, this is the Millard, the copy.
Can I get a copy? Even to him?
Yes, yes. I just know.
Just now.
Just now.
Incidentally, after so much of searching, we have been able to also find the notification because it was put on the website. We could see the cabinet decision was 2 days after the single judge's order. That was our hunch. So what was continuing, that policy was changed 2 days after the single judge's order. And that's why, and prior to that, there was a policy on which basis there was the division bench judgment, and I was seeking the similar benefit. So that's the reason, my lord, 3 questions were put up by the coordinate bench and also subsequently by your lordships. And last chance was given. Now I have got the notif. I don't know why my learned friend has same note. Yes. This notification is no. Why you are saying same? 2005. My lord, what I find is. No. My lord, what I find is, no, he has not given. Mr. Sengupta has not given the notifications. This is not.
Possibly that was not
This
the
is-
queries of the court.
My lord, they cannot suppress something.
No, we have not suppressed.
Let-
He
let-
is
let-
he's
let-
misleading the court in that
No, no,
event.
let's see if I'm misleading. This is after 3-4 occasions, one document lordships were constantly asking for, and the notification was not brought on. Well, I have got the notification itself. Seventh March. But the instructions that Mr. Sengupta has given, that speaks in my favor. Because now he's saying that notification of 2010 is still inoperative, and that was all my.
Given an interim protection.
Yes, there is an interim protection.
No, from the order of the coordinate bench of 3rd May.
3rd May, 3 questions were put.
Uh,
Interim protection was given before
that
that.
has been now brought this 8th October 2000.
To my understanding, still today, the estate manager Kollani has not apprised your lordships with the new notification. I have the copy, though this is.
No, this 8th October notification has gone. 8th October 2010.
In my understanding, there was a cabinet decision on 6th.
October.
No, 6th of March. The single judge's order was 5th of March.
Achha.
Sorry, sir. 5th of March, 24. That was the order under challenge. Now the estate manager Kullani, prior to the cabinet decision of change of policy, this is the policy change, they have done something. Now I said that you cannot do it, you have to do it on the basis of your existing policy. On that day, the policy, this notification was not brought on, which is the new one. Lordship, may kindly have a look. This is the new one. This is the new one. And this does not have, they are asking money from me on the basis of this notification. I say that you can ask me money on the basis of the old notification.
No, they are not telling about that. They are relying upon 8th October 2000.
Then I am happy because their action is, may I say this? They are asking me to pay 54 lakhs.
On the basis
59
of the
lakhs.
decision.
On the basis of new notifications, which
No, that new amount was sought from you for cancellation when it was made.
Lordship, may kindly
2001.
Yes. Lordship, may kindly have a look. I make a basic dates.
No, let us cancellation was in 2001.
One.
It was in 2001.
So at that time, this 8th October circular did not come.
At that point of time, 8th circular was
not there.
Now then, you paid the first installment, second installment. There was some delay, 6 years delay
on the last installment.
Last installment.
And I paid that also.
They cancelled.
I paid that the third installment
They
also.
received.
They received it.
We have returned the same.
They received it for a period of 1 year, 7 months. They kept it silent. Thereafter, I asked for the possession. When I asked for the possession, they gave me a notice saying, we are returning your money. And that is all. There was no termination letter even being served on me.
Then what did you do?
I challenged, my father challenged. Now, because now it is widow and
before the
and there was an interim protections to the effect that whatever would be at that point of rate for this kind of land, that may be given. And I was agreeable to that. And that's the reason they did not utilize the land. It was kept pending. Ultimately, when this matter was disposed of, 3 days after that, this new notification was brought in.
When was the order of cancellation?
The order of cancellation, my lord, it was of 15th of January 2001.
Is that page 47?
Do you want to show us the new notification which was taken 2 days after the order?
Only for the purpose that you're asking of 59 lakhs is in terms of the new notification.
Very good. That is not on record before us.
No.
Well, I have no difficulty if the new notification is not relied on. If my learned friend relies on 2010 notification, I'm very happy about it. Because now the Honorable Division Bench have interpreted these notifications and in the similar situations have also granted the relief to the other persons. I say that even my case stands on a better footing. How the state can make...
Mr. Sengupta, do you want to inquire about this notification?
My Millet, I just indicate few things, Millet. What is the genesis of this case? Genesis of the case is that somebody was allotted a land. Millet, kindly have a look onto the page 53 once.
Then we will ask him to place.
Millet, possibly it was not even required. Kindly hear me for a moment.
Be sure that
it is not even.
What is
not required?
Not required.
Okay, very good. Then you argue.
Yes.
He says that the new decision is.
I would be extremely happy for that. Extremely happy. Then
may I continue, Millet?
No, then let him place. You are
very well.
But you may kindly take the basic dates. No document may be.
But Mr. Sengupta, how can you say without going through this notification which is handing over?
This is the primary mother.
This is the mother notification. Subsequently, this has been changed and modified.
Yes.
Time to time. Millet, what is his locus today? His locus is that he is not the transferee. This but
to know about the circular.
Quite well.
And that for the last.
Millet, kindly I just
Well,
indicate
this was
two
not
things.
produced because of a reason.
A
I have
person
not said this for
cannot
the last
take
three
the
questions.
advantage of his
Let
own
him-
wrong.
let him-
Very well.
Lordship, you may kindly have a look. This basic dates.
We made it touch now.
গরম লাগছে
চক্রবর্তী এসছে Oh, he's there.
কি বলছো
Come tomorrow, Mr. Dhar. We have 1 p.m. when one
Oh,
matter has been fixed.
It will
Tomorrow,
not
all right?
take much time because on this 3-page, it will be very short.
Lordship,
কপি দাও
Of course.
okay, come on Monday. Come on Monday. Monday, you are in problem. Monday?
Well, in that case, can it be Tuesday? My learned friend.
Tuesday.
দাদা ওই নোটিফিকেশনটা দাও কোনটা দিকে
তুই একটার সময় ম্যাটারটা দাও।
Lord, I'm appearing for the writ petition of respondent.
Lord, I had requested for 5 minutes of your lordship's time before my learned friend starts. My lord. Correct. Lord, I wanted to cite a decision, my lord. Lord, if your lordship is pleased to kindly take 2020 volume 16, Supreme Court cases 489.
Just Mr. Bandyopadhyay, just remind us.
My lord, for a mining lease, we had floated an NIT. The petitioner had participated. The NIT had two clauses, 6.3 and 6.4, which required the intending bidders to carry out an inspection before putting in the bid. Now, after putting in the bid and after becoming successful, they were supposed to put in 1/3 of the bid amount, which comes to about 66 lakhs in this case. Now, my lord, without putting in that bid amount, they gave us representations saying that the land block, the sand block is not feasible for multiple reasons. Two reasons being, one, it is on the other side of Subarnarekha river, and therefore a bridge has to be constructed, which they cannot do because of an NGT order. And second, in the second representation, they said enough sand is not there, so it is not viable. So these were the pretexts.
Where is that representation of theirs?
Well, the representations are at page 64 and 66 of the stay application. And also in the reply, but 32 and 33 of the reply.
Yes. So your argument was by this order, the terms of the contract
Contract
have
is
been
rewritten of the NIT.
NIT
has been rewritten because the NIT required the inspection to be done beforehand. Now, the order, though it sounds innocuous, if the order is upheld, my lord, the situation will be such that 6.3 and 6.4 becomes redundant. Every bidder from tomorrow will come before the writ court without inspecting, will get a sand block and then come before the writ court saying that I want the inspection to be done now. It is not feasible anymore.
So we at one point heard Mr. Chakraborty saying clause 5. Will you show us clause 5?
All right.
Clause 5 version?
Rule 5.
Rule 5. Or he will give reply to that. Let him place. Yes, so your contention was that for that reason the terms cannot be rewritten now. Now, when was the bid amount paid by them?
It was not paid. They have not
all paid.
No. That is the contention. When we sought for that bid amount, they came before the Honorable Court, citing, praying for cancellation of the entire process.
Now, where is that letter by which you sought for the bid amount?
Yes.
That
My lord
is
will, my lord will kindly take.
in your reply.
My lord, I'll just give it, my lord.
2nd of February 2018.
2nd of February 2018.
Yes.
Letter is there in the
Yes, my lord, affidavit in opposition, page 40. If your lordship kindly.
page 40.
page 40 of my affidavit in opposition. My lord, I have prepared a list of dates with, my lord, the page numbers. My lord, if your lordship kindly have a look to this. My lord.
Yes. Very good. Yes, with judgment now you are saying that was your sole point.
Yes, yes. And one of the other point, the ancillary point is that this order has been passed after considering a coordinate bench's decision. That coordinate bench's decision, which is quoted in the impugned order, your lordship will find that is on the concession of the learned counsel appearing for the state. That submission was by the state. So these points were not taken there. Malad, I was placing Malad 2020, volume 16, Supreme Court cases, 489. Finally, take paragraph 20.
Para 20.
20. Malad, from 7 to 19, other decisions have been dealt with. Then kindly take paragraph 20. The essence of law laid down in the judgments referred to above is the exercise of the restraint and caution, the need for overwhelming public interest to justify judicial intervention in matters of contract involving the state instrumentalities. The court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of the requirements, and therefore the court's interference should be minimal. The authority which floats the contract or tender and has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will only interfere to prevent arbitrariness, irrationality, bias, malafide, and perversity. With this approach in mind, we shall deal with the present case. Malad, there are other decisions also. Malad, 55.
This proposition is well settled.
Yes, Malad, or Malad,
he cannot sit in appeal with the of the terms of the
and Malad, the tender terms cannot be rewritten. That is Malad, Malad, even Malad, other division benches, Malad.
Yes.
Malad, if I may place one where the articulation, Malad, is Malad, I found to be appropriate. Malad, this is 2021, volume 4, Maharashtra Law Journal, 311. Para 55. Well, the presiding judge in this, it's only a coincidence because the judgment is authored by Justice Kulkarni.
Yes.
But, yes. When a party invokes the jurisdiction of the court under Article 226 of the Constitution, it is taking recourse to a public law remedy. A writ would not be issued by the court to incorporate and or introduce a new term and condition in the contract executed between the parties. The petitioner, even at the stage of entering into a contract, would not have sought interference of this court to adjudicate as to how the terms and conditions of the contract would be framed. It is settled that the state has a free hand in settling the terms of the tender and the contract to be brought about. A judicial review as to what should be the terms and conditions of an agreement is certainly not the jurisdiction of the court, and that too the extraordinary jurisdiction under Article 226 of the Constitution. If such interference is made, it would amount to this court sitting in appeal over the contractual freedom exercised by MSRDC. Furthermore, the court, by exercising jurisdiction, cannot rewrite or vary the terms and conditions of the contract. Once the contract was entered between the parties being governed by the terms and conditions of the contract would be a normal rule. There is nothing exceptional in the present case which would require a judicial review of the contractual position taken by the parties. This more particularly when the parties have acted under the contract and contractual period having already come to an end. There is no public law element involved in the present case as to exercise the powers of judicial review in the present proceedings. In our considered opinion, a writ petition under Article 226 of the Constitution in the present circumstances for the prayer as made in the petitions to provide for arbitration so and so is not maintainable. This even assuming that the state notice so and so. The last part is not relevant for us, but their arbitration was prayed for.
Yes.
Malad, may I give the citation of the other two without reading it, Malad, or As
You
your
want to add further? So yes, give us.
But since this is my best point, my lord, I want to, my lord, buttress that point, my lord,
Yes, yes.
whichever way is possible.
Give us
No, no,
the
it had
reference.
Yes. My lord, it is 2019 SCC Online Delhi 9354.
Para?
Para 19.
9.
19.
Yes.
Yes. And we are unable to agree with the aforesaid submissions of the petitioner, as it is not for the court to rewrite the terms of the tender documents which stand purely in the domain of the respondent number 2. One, the tender conditions required certain documents to be uploaded with the pre-qualified bid. It was not open to the petitioner to upload them with the technical bid. It is not our domain to cure or rectify the errors and the mistake made by the petitioner in complying with the tender conditions. Well, here also they did not take the inspection when it was necessary. Now their error or their mistake or their that cannot be cured by the writ court, my lord, by passing the interim directions. And the last one, my lord. Well, this will be to 2020, volume 6, Maharashtra Law Journal, page 532. Paragraph 51. Now, after considering a few Supreme Court decisions, my lord, in the earlier paragraphs, kindly takes 51 in the second last page. That having regard to the study of various decisions of the Honorable Supreme Court and this Court Supra, it is clear that the scope of judicial review is very much limited in the matters relating to award of contract by the state and its instrumentalities. Thus, from the judgment Supra, it is clear that the scope of judicial review is very limited in matters relating to award of contract by the state and its instrumentality. The judicial review is not an appeal from the decision. The court cannot substitute its own decision, and the court is hardly equipped to do so. It would not be desirable either. It is not the function of the court to act as a super board or with the zeal of a pedantic schoolmaster substituting his judgment for that of an administrator. Unless the court comes to a conclusion that the decision maker has not understood the law correctly that regulates his decision making power, or when it is found that the decision of the decision maker is vitiated by irrationality and that too on the principles of Wednesbury unreasonableness, or unless it is found that there has been a procedural impropriety in the decision making process, it would not be permissible for the court to interfere in the decision making process.
Yes.
Now, the pedantic zeal of a pedant, that is also there in Tata Cellular also, my lord, and my lord, and Aravali Golf also, my lord, same thing by Justice Karju. Therefore, my lord, this, my lord, unless it is held that this 6.3 and 6.4 is so unreasonable and arbitrary that it causes prejudice to the writ petitioner, this 6.3 and 6.4, my lord, cannot be rewritten by the writ court, my lord, making it completely nugatory.
Thank you. Yes, Mr. Chopra. We heard you at 2 o'clock.
Well,
Any problem you have?
my lord, I'll just seek only one accommodation with regard to counter these judgments. I am ready, my lord, with the argument. But my lord, the judgments today they have cited.
How long will you take?
My lord, I'll take an hour. Subject to your lordships. An hour, my lord. Because, my lord, the factually, the position is different. What my learned friend has submitted, my lord, because I have prepared a list of dates to, my lord, argue, my lord, on the basis of facts. My lord.
It might be different, but I have submitted within the scope of the writ petition and the prayers.
My lord, may I just continue at 2, my lord, if your lordship subject to, my lord, if your lordship's convenience. May I just
No,
continue at
then
2?
again, if
Yes,
we
my
have
lord, that will.
time, we will hear. We have heard him, so we will finish it off and either pass
As
the
your
order
lordship
here
pleases.
or we will
My
reserve
lord,
it
my
if
lord,
the time permits.
my lord.
But the 2 p.m. we have another fixed matter. কালকে লিস্টে থাকুন। Mr. Mondobadhyay has finished.
My
His
lord.
junior will be here. You complete any reply required, you come and tell us.
Yes.
It will be there in the list, but we are not indicating the time. If we get
As
it.
your lordship pleases. No.
Okay. Mr. Bandyopadhyay, learned advocate appearing for the appellant, has concluded his argument, placing reliance upon, has concluded his argument. Stop. Leaves the matter for further consideration. আচ্ছা শুক্রবার রেখে দাও, ফ্রাইডে, হ্যাঁ ফ্রাইডে রেখে দাও। ফ্রাইডে আমার মান্থার সাথে বেঞ্চ করো for further consideration on না তারপরে লিখো ডিউ টু পসিটি অফ টাইম মিস্টার চক্রবর্তী লার্নেড অ্যাডভোকেট, না ওটা ভুল। না কালকে মান্থার সাথে heard Mr. Bandyopadhyay, learned advocate and for the appellant has concluded his arguments, leaves the matter for further consideration on Friday দিয়ে দাও, ওনার নাম দিয়ে দাও।
Grateful.
ফ্রাইডে প্লিজ, হ্যাঁ কোন দুটো ফিক্স আছে নেই?
ফ্রাইডে
ঠিক আছে ফ্রাইডে থাকুক, দেখি তুমি উপরের দিকে রেখো এটাকে, এই গ্রুপটা।
Grateful.
Hold the list.
Lord, may I remind you, Lordship, that on the last occasion, a matter between me and Mr. Tapon Mukherjee, your Lordship, observed that if the matter is appearing as serial number 30 today, your Lordship observed that if the matter is not taken up today, your Lordship gave us liberty to mention so that your Lordship can fix the matter on any day subject to your Lordship consent.
Who is you're there?
Ma'am, sir, I was instructed by Tapan.
Mr. Bhattacharya, coming 2 weeks, we have 2 p.m. fixed matters. So that is why we did not fix the time. If it is reached per chance, we can finish it off. Coming 2 weeks, this week and the coming week, all the days 2 p.m. matters have been fixed.
Any subject to your Lordship consent.
So you will not, you want it when? We will keep it on the same
Any
day.
time on any day you also can leave.
We are not in a position to fix the time today because otherwise it will not be taken up for the last two weeks, coming 2 weeks, because we have fixed matters at 2 p.m. Please wait for this week and remind us on Monday. If any gap is there, we shall put it. Yes, call.
My lord, although this is not
Why
the
you are
time for
mentioning
mentioning,
now? This is not the mentioning time.
attend, ma'am.
Come and mention tomorrow.
First of all, wish your lordships happy and prosperous new year.
What do you want?
Just leave to file without certified copy, my lord.
Leave
to file without certified.
When was the order passed?
12th December.
Come tomorrow, mention in the morning. Yes, call the list.
First of all, wish your lordships a happy prosperous new year. And my lord, today I am for the respondent. Number 1, I am filing affidavit of opposition.
What
And copies to the out.
Affidavit in opposition? Why? All the
That matter was, I am deprived of pension. You also remember that and please today.
No, we don't remember. We did not ask you to file any further affidavit.
Everything is on record.
Huh?
Everything is on record.
No, affidavit of opposition perhaps has not been given therefore. Is your lordship here?
No, it is not our choice. Then you give a copy to Mr.
Yes, I have served the copy of it.
So let him check up that. Come back if he wants. If you want to give any reply to that, you give a reply and come back, Mr. De.
As your lordship directs, that will happen. As your lordship directs.
Appearing for the respondent number 1 files an affidavit in opposition. Files an affidavit in opposition to the
This month. Lordship, kindly extend.
Do you want to use any reply to this?
Today just I do not know. Nothing.
Lord, how can it be, Lord, if you will give reply? As your lordship directs, I shall comply with it, but there cannot be an interim order extension because
if we cannot hear the matter, it has to be extended.
As your lordship, as your lordship. But my lord, kindly fix the date, my lord. It will be.
Acha, a copy has been handed over to Mr. De in court today. Mr. De press
with permission, my lord.
Any other respondents are there?
He is the contesting respondent, I am the.
What is the matter about pension?
Milord,
It's very,
Just
yes.
point is very short.
Pardon?
Point is very short. Upgradation has been given, but not the promotion. Promotion has been thereafter regularized. He was an employee of WBACB with a scale.
Mistake.
WBACB. Then he joined WBPDCL. With a scale, he was stenographer 2, and thereafter there is a rule in WBPDCL that if there is no promotion for 15 years, the scale will be upgraded, but he will be in the lower grade. As far the status is concerned, it has been upgraded. Then career advancement scheme was there. Then thereafter ROPA 99 came. Then everything has been regularized. His promotion has been given the day ROPA has come on a subsequent event. Now he has been fitted. So when he was, his entry level at WPDCL was at the scale 8. In ROPA 99, there was no scale 8, there was scale 9. And scale 9 was revised to scale 10. And he was given as per ROPA scale 10. And thereafter, and the promotions, corresponding promotions grade was senior stenographer.
Then ultimately what? He's still in service?
No, he has retired. He was asked for he asked for he was called for promotion 6 times to appear before the selection test. It is not
now he has retired, he is getting his pension.
Everything is there.
No, my
So
lord.
it is a question of enhancement of the pension which
Nothing.
he is claiming.
That is all.
One thing that I am mentioning, I am getting pension of rupees 2,500 only. Your lordship will be surprised. I am deprived of getting promotional benefits. And in that respect, the honorable justice.
Sir, we will consider.
Yes, careful donorship.
Yes, next. Doctor. Yes.
For the applicant. There are 3 applications, my lord.
Applications for?
One is application for, my lord, leave to appeal. Another application is for condonation of delay, and another application is for appropriate order. Well, what has happened? The appellant association was the private respondent in the writ petition, but he was represented through the secretary. Secretary now it is changed. So it was by name party was added, and secretary now changed. That is why the leave to appeal. The new secretary, he was not the party to the original writ petition. That is why this is the leave to appeal.
Secretary was made a party by name in the writ petition.
By him in the writ petition. He represented the bus associations, SD16. So that is why the new secretary is now changed circumstances.
No, come, let us see. So as the writ petition cause title, chairman was implemented.
My lord,
Respondent was 7.
in the original writ petition, if your lordship kindly comes, pay respondent number 28.
Respondent number 28.
If your lordship handwritten, my lord, many respondents were added.
Pursuant to the order
Yes.
of the Honorable Court dated such and such, passed in respondent number 28 is added.
Alimul Islam Khan, Secretary, SD16 Bus Owners Association.
Very good.
So now Alimul Islam Khan is no more. It is Shurabuddin Molla is the said new secretary. That is why this is leave to appeal. Alimul Islam Khan is asked for a secretary.
And who are these respondents? 13 to...
Those are another different associations. It is a matter relates to, my lord, all these bus owners using the land of the petitioners for parking their vehicle after getting permit from the state of West Bengal. They use
respect of their land.
Their land, petitioners' land, writ petitioners' land. We are using this land for last 20 years as parking. We are parking.
What did the single judge say?
No, single judge, my lord, as because it is not notified as bus stand, so directed to hand over the position of the plot of land in favor of the writ petitioners and not to park any bus over the land of the petitioners, my lord. This is the main substance of the writ petition, my lord.
And what of the other bus associations have not
Not
challenged it?
challenge this order, possibly. If I am not wrong, they have not any preferred any appeal. So we have to come up, my lord. I have nothing very much to submit before your lordship, my lord.
Yes.
Anyhow, even after that, my lord, it is my duty to point out, my lord. That is why, my lord.
Yes, point out
So-
what is
so
the wrong in the order.
My lord, what has happened? So leave to appeal is with regard to that, and there is a delay application, possibly, my lord.
All right, we
Something
will grant
400
you
days
leave to
delay.
appeal. You argue on the merits of
If
the
I go to the merits, my lord, my respectful submission is that, my lord, when a as my lord, we have been given
Yes,
them a
yes,
permit. My lord, when we have been given permit, my lord, it is our we need to, my lord, park the buses as because it is a not 24/7 bus cannot run, my lord. So we need to park. It is the government of West Bengal, my lord. They should
show us that permit.
Before going, may I?
We come back, Mr. Bera. He has.
No, there are certain backgrounds which are required to be before going in.
We will listen to you.
Before going into the merit, the background has not been stated. That's why it is causing confusion. Very well, your lordship, I will make my submission very.
My lord, page 21 is the permit, my lord.
Page 21 of your stay application.
My lord, stay application. Page
Oh,
21.
this is
Annexure B. My lord, can 3.
পুরো addition of party হবে। Yes.
My lord, can 3, my lord. In can 3, page 21, my lord. It is the
Can 1.
Can 3.
It will wait করে দাও না can 3. Can 1 টা কি?
Can 1 is leave to appeal.
That's why I'm telling you, 3 applications are there. I objected.
6.
Only your lordship restricted to the hearing on the whether he has a right to leave the appeal. That's why your lordship directed us to file opposition to the leave application. We have used that. They have not used any reply. So, right to whether they have any right to file the appeal, leave to file the that should be decided first.
What is the utility? We'll decide the appeal. Again, we will allow leave. If we grant leave or we refuse leave, again proceedings will go.
After 2 years, already finish it off.
Oh.
You are for?
Hey,
Who are they?
Well, I am sorry.
Why
I'm
you have-
ready. I am handing over, madam.
Acha, so take us what you are showing.
My lord, your lordship asked me to show the permit, my lord. It is page 21 onwards. My page 23 is the permit.
Page 23 of your if to appeal application.
No, my lord. Can 3. Application for appropriate order. Can 3. My lord, clause 7, routes for which permit is,
just-
my lord. Section 5.
Yes.
Well, from
Page কত হলো?
at least for month.
Yes.
For last at least 20 years, while we are using the land of the petitioner. It is admitted position that is the land of the petitioner. It is not our land. It is admitted position. So they have never raised any objection towards that. We are using that land. Now all of a sudden they came up with the petition challenging that we are using the land. We are.
because there are other buses also. At least more than 20 bus association were parking over there for last 2
Page
days.
32.
My lord. Oh, my lord, it was initially an order was
Page
passed
20, you showed us page 21.
21 onwards.
Permit holder is Alimul Islam Khan.
My lord. At that point of time, he was the secretary.
I see.
Initially, an order was passed in the writ petition. Challenging that order, an appeal was preferred on our past occasion, my lord, which was allowed by this honorable division bench, erstwhile division bench, my lord. Honorable Justice Shamadar was there, presided over the bench. His lordship allowed the ground that on the ground we were not made the party in the writ petition. This association was not made the party to the writ petition. So natural justice was violated. His lordship given leave to add us as party respondent to the proceeding and remanded back the writ petition for final hearing. So then this respondent number 28 was added. Pursuant to that order, my lordship have seen. So this respondent 28 then added. Then after that, my lord, this writ petition is second time heard and decided in favor of the petitioners. This is the.
So what did the trial judge say?
My lord. Finally comes to.
You show us the relevant portion of the order.
My lord.
You are impugning 15th May 2023 order.
No, 10th May.
10th May.
Sorry, I'm sorry, my lord, 15th. I'm sorry, 15th May. These are all the background, my lord. Provisions of laws, section 1, rule 182 of 189 rules, 1989 rules were enacted. 50, 51, all are told. Paragraph 50, paragraph 18, my lord, page 53 would be the particular. For the purpose of using a paragraph 18, 18, page 53. For the purpose of using a place for bus stand and halting places, the provisions laid down under Rule 182 has to be complied with. From the report of the district magistrate, it is evident that the provisions laid down under Rule 182 of 189 rules have not been complied with insofar as the plots of the petitioners are in question. In view thereof, this court is of the considered view that the aforesaid plots of the petitioners cannot be used for parking the buses. Furthermore, the allegations of the petitioners that the vehicles have been parked in the property of the petitioners also stands proved from the report of the Commissioner of Police dated March 21, 2017. In view thereof, this court is inclined to dispose of the writ petition by passing the following directions. No bus shall be allowed to park on the property of the petitioners, being RS plot number such and such.
What is 182 and 184?
My lord.
182.
My lord. My lord, page 50, 50, paragraph 15, 15. It is relates to, my lord, stands and halting places. Rule 182. The district magistrate of the commissioner or the commissioner of police, as the case may be, by notification in the official gazette or by the erection of traffic signs which are permitted for the purpose under subsection 1 of section 116 of the Act, or both, may in respect of the taking up or setting down by passengers or by both, by public service vehicles or by any specified class of public service vehicles, conditionally or unconditionally prohibit the use of any specified place or any place of a specified nature or class, require that within the limits of any municipality notified area, cantonment, or within such area of the limits as may be specified in the notification, certain specified stands or halting places only shall be used, provided that no place which is privately owned shall be so notified except with the previous consent in writing of the owner thereof.
Now, where is the commissioner's report? Report of the DM and the commissioner's report. Show us those two.
Those are not with because I was not then, my lord. It was exchanged in the.
No, the court refers to the
my lord. It was exchanged during the course of the proceeding, my lord. It was exchanged at that point of time.
Now, what is your ground of challenge, Mr. Bera?
My lord, my grounds of challenge, my lord, that it is a.
Oh,
I am
Okay, continue.
Yes, ma'am. What has happened? The grounds of challenge, my lord, the lead court is gone into the aspect of civil court, my lord. It is my ground that
Gone into the aspect
of civil court, my lord. It is a nature of civil court, my lord, that to hand over the possession of the land we are using, my lord, without going into the
No,
facts.
it is a question of utilization of the land in terms of the motor
This is
vehicle.
my
Just a minute. Report is there.
Let him,
For the report I have annexed.
in your opposition.
Yes, page 208, page 208, but original report is there. Page 208 of the opposition.
Page 47 of the option. His application already filed with court of the clearing court.
This was called for by the court. DM
Court.
That is
Page
after
208.
it was sent back on remand.
Yes. No. But what happened in this case, my lord, initially we moved the writ petition. Number after exchange of affidavit, writ petition was heard and disposed of my lord, Mr. Justice Dipankar Datta. Number his lordships also directed in view of Rule 82 of 1989 Bengal Motor Vehicles Rules, nobody can park. It must be done by the government by notification and consent of the owner is necessary.
Where is his order? Where is the order?
I am telling you that order, my
Then against
that order
that-
has been set aside. Now, my lord, that order, before that, the report was obtained by my lord, Mr. Justice Dipankar Datta. That was at page 208. That was, my lord, that report was submitted by the order of my lord, Mr. Justice Dipankar Datta. Now, my lord, that order was challenged by the secretary in his own name, Alimul Islam Association. Now, my lord, on the technical ground, that the notice has the lordship come to page 208. But since the order of my lord, Mr. Justice Dipankar Datta was set aside by appeal court, we have not annexed that in the report.
Well, it is annexed in my application, well, page 33.
Very well. But page 208, your lordship will get the report.
So this was the report filed before after this the appeal was dismissed.
No.
After this report was filed.
After this report was filed, the writ petition was allowed, asking the government and the all private owners that please hand over possession of the land to the writ petitioners. That order was challenged by one Ali Muslim Islam Khan, secretary of the present appellant. Name has been changed. In the meantime, that was writ petition, that order of Justice Datta was set aside only on the ground that Alimul Islam Khan or the secretary of Owner Bus Association was not made a party. Then the matter was remanded back and court asked implead the secretary Alimul Islam Khan as party to the writ petition. Then Miller, pursuant to the direction, we added him as party that has written in the cause title. Thereafter, after remand, we file an application for amendment of the writ petition because so many bus owners association or bus operators are there parking. So, we made certain amendment of the writ petition and also changed the writ petition to the representative capacity. And we made public advertisement pursuant to the direction of this honorable court. Now nobody can say that I have annexed everything.
Show us. Show us.
Yes, my lord. All orders, my lord, I have annexed. My lord, kindly come. Before that, my lord, I am telling that
The
Mr.
main
Bera,
ground-
we will hear you. Let him complete his argument.
Let him complete his argument. Your lordship
Yes.
asked for the report.
Only
That's why I
report,
pointed it out.
yes.
That's why I pointed it out.
You tell us what are the grounds you are challenging.
My lord, ground one is my challenge for regarding that.
No, come to your ground 8. 8. What you are saying, ground 8? Eight 182 applies to land which is used as standing or halting place for sale, and since the said plot is not being used by the members of the appellant association, no order was required to. Your main ground is they ought to have gone to the civil court for obtaining back. This is your
This is main, my lord.
yes, Mr. Beta. Why you are opposing the leave to appeal?
Leave to appeal, the grounds of leave to appeal is that the matter.
Are you pressing on that?
Yes, it shall be dismissed. The application for leave to appeal should be dismissed first because they could not make any case for leave to appeal.
Then we cannot go into the merits of the claim.
No, just a minute, Milord. Their conduct must be, Milord, must be produced before your lordship to how they have proceeded with the case. Thereafter, your lordship.
Two aspects. If we don't allow the leave to appeal, matter ends.
Yes.
Because there will be no appeal in the eye of law, everything goes. But we would not be going into the merits of the.
Yes. Second,
now, if the leave to appeal is not seriously opposed by you, we can take up the entire matter for hearing.
Take up the entire matter. Of course, I am seriously opposing because some misstatements are there. But Milord, I will go into the merits of the case because this is, so far as merits of the case is concerned, your lordship I have quoted or your lordship wants the book, I can produce the rule 182. Now, this is the crux of the question. We are the owners of the land. Now, my lord, in order to, my lord, create a bus terminus, it is necessary government must publish a notification in the official gazette. That is absent in this. I am telling on merit. That is absent in this case, and that report was obtained by my lord, Mr. Justice Dotto, and report is clear. Report of the Commissioner of Police in consultation with the District Magistrate South 24 Pargana. So Rule 182 has been violated. Now, my lord, Rule 182 is violated. So it's a statutory violation. Nobody, my land cannot be used without for bus terminus without publication and notification in the official gazette. With regard to merit, I am telling you. Without, that is Rule 182 that has been quoted there. And if your lordship so want, I have brought the book, I can produce.
Yes.
So that is the statutory violation. So if there is a statutory violation, question of Milord using the land or acquisition of title or acquisition of possessory title by some bus owners does not arise. Because your lordship knows, Milord, that they are parking their buses not by their own choice. By their own choice, they are not adversely coming into my land. They are using the land on the strength of a permit issued by the government. They are supported by the government document. You are given a permit. Permit means, permit consists two parts. One, where the bus is to be parked, or from this route it is to be, from that route.
In permit where the bus has to be parked is mentioned.
Yes, it must be. It must be. Because
route is mentioned.
Route is mentioned.
And as per notification under Rule 182, the lifting of passengers will be fixed.
And in the route, Milord, there must be two terminus.
Yes.
Without terminus, there can be a route can't be fixed. So this is one terminus, that is one terminus. When they are using the terminus, it requires land. And not only that, besides the private operators, 4 statutory organizations were also using the same place as Bastard. It is admitted fact. They have, after filing of the writ petition, they have withdrawn their passes from the terminus. Now they are continuing, they are claiming that they have acquired some title, possessory title rather.
No, Mr. Beda, we can follow. There will be 2 terminus, all right.
Yes.
But for lifting of passengers, prerequisite is that the space has to be notified and fixed by the state in terms of Rule 182.
Yes.
That is your contention.
Yes.
So this 182 notification was never there.
No, never there.
So they have started taking the passengers from a particular spot which has no legal sanction.
Legal.
This is your argument.
Yes, this is my legal.
Yes. And in the absence of any legal sanction, there arises a statutory violation.
Yes.
As such, I can come to the writ court to get back my land. This is your argument.
Yeah.
Very good. To that effect, you have to point any other thing, any other ground of challenge.
Other ground of challenge, your lordships know, so far as that they have said, etc., limitation, etc. Your lordships say that. I can cite some judgment.
No, limitation about why you are, what is your ground of challenge against leave to appeal?
Leave to appeal against, that I say, in the leave to appeal, they have said that suddenly the matter appeared in 2024. They have said that they have not been informed about any listing of the matters or notice regarding hearing of this case. That I have explained in my opposition in paragraph 14. From all paragraph 14 regarding service to Alimul Islam Khan, he did not appear at any point of time. In paragraph 14 of the opposition, I have given the gist.
No, when did he come into that post? What did he state?
But he said, he come into this post after some period in Milord, after they have.
Which paragraph have you stated?
I have said in paragraph.
No, their paragraph.
Their paragraph is, there has been document has been annexed.
Yes,
that document has been
Secretary was properly represented.
Yes, that's why I have also said in the opposition.
I come.
Alimul Islam Khan was along there.
Why name was?
They have created a document that after some time, so long as Alimul Islam Khan, we have served notices up to the last stage, up to the final hearing. We had no knowledge about this change of the name of secretary. Now only case is that name of the secretary has been changed in the meantime. So notice has not been served. But fact remains is that we have served all along upon Alimul Islam Khan. And not only that, the Honorable Justice Bhattacharya, when hearing the writ petition, as a last resort, asked us to serve the learned advocates who appeared before the appeal court at the time when the writ petition order of Justice Dipankar Datta was set aside. We wanted to serve, they refused to accept. After that, his lordship proceeded ex parte against the.
Which paragraph you have said? Which paragraph you said that? Which paragraph?
Paragraph 14 of the paragraph 14. All documents I have given. In paragraph 14, I have given up to the from all details regarding service. Regarding service upon Mr. Alimul Islam Khan in details, all after the amendment. From the stage of amendment, we have served all at all stages and filed affidavit of service. Some of the affidavit of service you have also annexed in his opposition. In details we have given. Now, after, and he has not, and after changing his name, he says no notice has been served. And Alimul Islam Khan has not been made a party.
Now, why he was made party by name?
No, he himself filed the appeal. Alimul Islam Khan as secretary. It is not that only secretary filed.
Which appeal?
They have earlier appeal. First,
Because he was impleted as Alimuddin in the
we
writ
did not
petition.
implead. We did not implead. Order of Justice Dipankar Datta was challenged by Alimul Islam Khan as secretary.
Right.
Yes.
Now, pursuant to the division bench order, he was impleted.
Yes.
So, upon impleadment, division bench order, you have not challenged. His impleadment was on the basis of the division bench order.
Yes.
Now, thereafter, the issue was to grant an opportunity of hearing to Alimuddin or Alinul, whatever. Now he has expired. After expired or he has left the post. Now the court, his argument is that in view of the fact situation, I ought to have been given a notice.
No, that is because the Alimul
There is
Islam, he has himself stepped into the shoes of Alimul Islam. He has not impleaded Alimul Islam Khan in this appeal.
Why he will implead that Alimul is no longer the secretary?
No, he was a party, formally your lordship knows, he was a party, why he not implead? He may appear, may not appear, but he was a party to the writ petition. He, deleted his name from the...
In the writ petition, this Justice Somaddar's order,
Yes.
by which Justice Datta's order was set aside,
Yes.
That appeal was preferred by the then secretary of that union.
No, Alimul Islam Khan as secretary.
Very good. By name.
By name.
So the court directed, show us the order of justice.
Page 37. Page 37 of my Can 3.
Can 3
Can
page
37. 37 is the initial order. Operating portion is page 39.
Matters shall be heard that upon I become expert. আমি বললাম নাম দিই particularly.
So whom did you implead in the Dipankar Datta's, Justice Datta's writ petition?
Mirror, Alimul Islam Khan was not impleaded.
Then the association was impleaded.
What was done by this court when we moved the writ petition, several statutory bodies, South Bengal State Transport, Calcutta State Transport, etc., those corporations, Surface Transport Corporation, those were impleaded as a party. Then on behalf of the state, advocates appear. He said, these are the franchises of the transport, these are the franchises of the government. They are parking their buses. Then the court directed, you implead them as party. They supplied the name. On the basis of that, we impleaded we impleaded respondent number 20. Originally,
respondent number
up to 9. Then West Bengal Housing Board from 11 to
27.
27. They
10 to
were
27.
added pursuant to the order of this court.
10 to 27.
10 to 27. So after that, the most interesting part is this: no private operators appeared at any point of time in during the hearing of it, and in spite of service. Now, my lord, after that, to our ill luck, Alimul Islam Khan came as secretary ST 60 years. He challenged the order on the ground that I have not been submitted notices. Then, my lord, directed this, the appeal court, honorable appeal court directed to add him by party. We add him as party. Then, my lord, application for amendment was filed. Amendment petition was served. Various orders were passed that we have annexed in the opposition. This court, my lord, kindly come to page.
So, Mr. Bera, fact remains the desire of the court was grant an opportunity of hearing to Alimul.
Yes.
Now, Alimul did not appear in spite of repeated notices,
yes,
which you have said.
Yes.
Now, what he has stated in his leave to appeal application that why suddenly now he has come.
Not that, after several service. Well, after several service, my lord, when he came into picture, kindly note the date. When he came into picture.
That is which we are wanting to know. wanting to know the date, what he has
Yes.
stated.
I am telling you, Lord. Leave it to appeal the application. I am telling you. Yes. Now he came into the picture.
Interesting. The appellant.
He came into the picture on
which paragraph you have stated?
page 23.
Page 29 of my leave to appeal application, my lord.
Page 29.
This present secretary, my lord, becomes the secretary on 26 September 2021 meeting, my lord.
Just a minute.
Can 1. Can 1, my lord.
What is your can 3?
Can 3 is appropriate order, my lord. Can 1 is the leave to appeal, my lord.
Page
29. 29. অধ্যকার সভা সবার
খুলে দাও তো।
No, you have become secretary,
26 September
as per resolution adopted on that date.
my
Okay.
lord.
So, my lord, up to 23rd September to up.
Can 1
For that, at least several orders have been passed.
Can 1 এর পেজটা কত বললে? 20
Page 29. 29.
29 or year
This is the resolution.
regulation.
29 resolution was adopted when?
26
September
September
2021. And Justice Homadar dismissed the, when did the appeal was allowed?
But in 2018.
11th of January 2018. Very good.
As a secretary, secretary has been the.
And my lord, one
Every
important
day there shall be a change. ওইটা ভালো করে
তাহলে তো লিভ টু অ্যাপিলটা ডিসমিস করতে হবে। সেটা চাইছি।
number one important
The order which shall be passed by us shall remain binding upon the secretary or even upon the person.
number one point with humble subject.
এটা কিন্তু last this order shall remain binding upon the person who will hold the post of secretary.
অসুবিধা হবে। এরই অসুবিধা।
আমাদের যে অনেক
মেরিটে তো মেরিটে জসেম দিয়ে বুঝতে পারছি না স্যাটিসফ্যাক্টরি
allow করবে the division
kindly come to page 215 of our opposition. 215. He is bound by the notice. We have made.
You are not strenuously opposing the prayer for leave to appeal.
No, since your lordship asked me, if your lordship wants to hear your
Present, we are disposing of the appeal. The present, the application being Can 1 of 2024 has been preferred by one. Urabuddin Mol, claiming himself to be the present secretary SD-16, bus owners apostrophe owners associate. We have allowed the appeal.
Not that we will not some direction upon the state to comply or
Not your appeal, sir. Go and file contempt before his law.
that is there, but
You want to strengthen
my
that?
client could have been benefited.
You want to
Order of
strengthen?
single bench and it's an order of division bench. The appeal would help.
Yes, we have dismissed the appeal. We have observed in open court. What more? হ্যাঁ বলে দিও আমি তোমায় পাঠাচ্ছি আচ্ছা এই ওকে ডাকুন দিও নাকি আচ্ছা records further reveal that
Initially, the petition was filed against the state and its authority. Thereafter, after the review of the election, filed by the all the private personnel was implicated.
সবাই এসছে
সবাই এসেছিল তারপর একেও নিয়ে আসা হয়েছে। তার মানে সবাইকে হিয়ারিংটা দিই।
আচ্ছা ঠিক আছে records further reveal that the writ petition was initially preferred impleading the state and its functionaries. However, subsequently, all the other permit holders were brought on record. Even thereafter, even all on pursuant to the order passed by the Honorable Appeal Court, the appellant herein was also impleaded to the writ petition. Pursuant to the order passed in the ওইটা কোথায় গেল ওই অ্যাপিয়ার করেছিল অন্য পাশে পারমিট হোল্ডার
ইয়েতেই পায় অ্যাপিয়ার করেছিল জানো এই যে
পার্টি করেছে অ্যাপিয়ার Did the other permit holders appear, Mr. Bera?
No private person never appeared except government and transport corporation. But that is recorded in the order of single bench, learned single judge. Recorded in the order of the single judge.
বাকি ছিল সব
ঠিক আছে ওটা
আজকে এরা এলো এসডি এলো কিছু দেশের লোকেরা
Yes, next.
Person appearing for the petitioners.
So this is that matter, my lord, where we have carried on the demolition proceedings even after a communication from the learned advocate that the Chief Justice. Lord, my lord, may I place the report, my lord? একটু দেবেন জজ সাহেবকে এটা I will find the 10-4. I'm sorry, my lord.
Have you given a copy?
My lord, I have given. My lord will appreciate. It is my statutory obligation that I am carrying on. But I have initiated the proceedings pursuant to an order passed by this court, which mandated, my lord, me to conclude the proceedings within a time frame. That there was much delay, my lord, but I had to proceed with.
That order?
My lord will kindly find the
initial order of, I will kindly give me one moment, page 70, my lord, 70. It is this order that the proceedings has been initiated, my lord. Order dated 5th of January 2022, my lord, page 70.
Hmm. order.
2022 order, my lord. Look, this mandated the page 71, my lord, will find. Accordingly, second last paragraph, my lord, accordingly, the writ petition is disposed of, directing the respondent number 3 to conclude the proceeding initiated
Was
under.
that 3? DM?
My lord, it was the assistant engineer.
What? Yes. To conclude the proceedings.
Even it-
Initiated under within 3 months.
my
Yes.
lord. So thereafter, my lord, the order was passed on 2nd August 2022. My lord will find that order from the competent adjudicating authority at page 83. And here the report of the page 83, my lord will find is the reasoned order initially passed. 10-3 order, my lord.
10-3 order.
But opportunity was given, my lord, to all. In fact, my lord, let him satisfy your lordship as to his ownership. It is a public road, my lord. It is highways. My lord, situation demanded, my lord, that I had, in fact, the situation demanded that I had acted more promptly.
Now, thereafter, they preferred a statutory appeal.
Thereafter, they preferred a statutory appeal, my lord. My lord, initially, the DA district magistrate had passed an order. My lord will find that order at page 106. My lord, this was the order of the district magistrate. My lord, a writ petition was filed challenging this order, that this order of the DM under 10-4 is a cryptic order. Well, the answer to the writ petition was at page 107, whereby the Honorable Court was pleased to direct the district magistrate to revisit the issue and, my lord, consider his case. Thereafter, the impugned order under 10-4 has been passed, my lord.
That was directed to be done within 6 weeks.
My lord.
Then what order was passed?
My lord, you'll find the impugned order at page 118.
118.
Oh, I'm very sorry. I'm very sorry. My lord, it is at 116.
Operative part.
Order of the DM 10-4 order, my lord.
Suit is also pending.
No, nothing, my lord.
Yes.
This is the 10-4 order, my lord, where the district magistrate has affirmed the order under 10-3. Well, deepest of humility, my lord, to my understanding, the latest proposition or the latest judgment of the Honorable Supreme Court, my lord, is very harsh, is very clear, and is very harsh as to the entitlement of an encroacher. Should I place the judgment, my lord?
Now the magistrate passed the order on 24th October
My lord.
2024.
My lord.
And the challenging the same
Writ petition was filed.
Was filed on 21st.
No, disposed of on 21st.
Writ petition.
This present writ petition was disposed of on 21st.
Where is that order?
Page 118, my lord. এই কবে ফাইল করেছেন রিটটা বলো?
No, this present writ petition
was disposed my lord.
Disposed of, we understand.
My lord, I'm sorry,
Was
my lord.
filed, when was it affirmed?
My lord, will kindly give me one.
On Tuesday, taking
16th December 2024, page 57.
On 16th December.
Hmm.
Now 18th and 19th Then why didn't you mention on that date, 16 December?
বলুন যে প্রথমে এটা ছিল না, কবে ওরা এ করেছে?
My lord, upon leave of the court, I filed the petition.
Why leave of the court?
Because of the we sought for early hearing because that there is a probability of demolition. The court allowed me to file the petition.
When?
On 6th, I filed this affirmation made on 16th, my lord.
Then when did you mention?
17th, my lord.
Where did you state that? Now it came up before Justice Kaushik Chandra.
No, my lord.
Yes.
This 16 December
It came up for hearing on
20th.
Aniruddha Roy, sorry, my lord.
So,
Sorry, my lord. But
where have you stated that in your application? Where have you stated that in your application, Can 1? That it came up before Justice Aniruddha Bose. Where is it?
on that very date, at the very initiation, my lord, there is a
Sir, please show us the statement where you have made in your application. You filed it on 16 December.
16th.
There was a miking on 18th and 19th. Then on 16th, after filing, why did you waste your time?
No, my lord, I did not waste.
Where is the mentioning, sir? Where have you mentioned in your application? You have in your application, para 1, you have stated the prayer. Para 2, you have said it was taken up for consideration on 20th December.
In a hurry, my lord,
Sir,
now, my lord,
this is a very sensitive issue. Kindly consider. This is a very sensitive issue. Here, we are saying that we asked him to take an information since the Chief Justice said that you are granted leave to move the appeal.
My lord, may kindly, with the leave of my learned senior, my lord, my lord may kindly come to page 117, my lord. The leave is endorsed.
117,
my lord.
117,
my lord.
This order of 24th October 2024 was challenged in the writ petition.
Yes, ma'am.
Filed on
This
16
writ petition
December.
was affirmed
Filed
on
16 December.
Yes, because on 10th December, this order was never communicated to us, my lord. That was my specific case. We obtained
which order?
The order of the district magistrate of 24th.
Sir, please, any one of you submit. Otherwise, it becomes very difficult for us.
Yes, my lord.
Either you allow him to address or you address. This interference creates difficulty.
Yes, my lord, let him say, my lord. No problem.
Why this is happening every time? I don't understand. What you are saying?
My lord, the order of the district magistrate, which is supposedly passed on 24th October 2024, was never communicated to me. I went to the office of the district magistrate several times, my lord. Ultimately, this order was handed up to me on 10th of December 2024.
Where you have stated?
From the office of the district magistrate.
Where you have stated?
My lord.
Irregular problem.
My lord, in my can 2 of 2024,
It's your mere statement.
Can
let them show.
Where?
My lord, can
Tell us where you are written.
Can 1 can 2 ta hota hai. Can 2 ta.
You people don't make any note, don't make any just your can 2 first paragraph is prayer quoted. Can 2 second paragraph says
My lord, kindly comes to page 10, para 9
of
can 2 of 2025, my lord.
Page 10, para 9.
Sir, this is very difficult to believe.
My lord, let them show they have communicated. Let them show they have communicated.
It was your presence or the order was passed.
No, order was passed. Hearing was done on that day. Order was passed, my lord, subsequent. Lordship knows, my lord.
You have to prove it is your case.
Yes, my lord.
You have to prove
I have
that you obtained the order. It was where is the communication?
It was never come. That's what is my case, my lord. I was handed.
Please read what you have said.
My lord, that although the order impugned before the honorable single bench was passed as early as October 2024 by the district magistrate, it was never communicated until December 10,
Very good.
2024.
So when it was not being communicated to you, was it not your duty to file a representation to fortify this fact that they are illegally withholding the communication? You slept for 2 months.
No, my lord, I went regularly to the office of the
Sir,
district
how
magistrate.
can you establish that? Then now you are going into factual issues. Have you written any one letter in support of your contention in paragraph 9? Please tell us.
My lord, I am told that we have given representation to communicate the order, my lord.
You do not annex that, huh?
Yeah, yes, my lord, we have given representation. We have not
Where
annexed
is that
it. We have
communication?
not annexed it, but I am told, I am specifically instructed, my lord, we have given.
This is a court of law, sir.
My lord.
We cannot repeatedly adjourn the matter and keep it pending.
I bow down.
Then it was your duty to annex that. You have not done so. So we are without any explanation as to why from 24th October till 16th December, 10th December.
17th December, my lord, we have filed it. On
16th December you
have
filed.
affirmed.
Now,
17 December,
17, 18, 19, 3 days he had for the first court
now
to pass
show
an order.
us in the writ petition you have stated that it was belatedly communicated,
The writ petition.
which you affirmed on 16th December. 16th December. Let us see where you have written.
My lord, with all humility, may I say this, my lord? When we came before his lordship, yes, my lord.
I think you have not written that there. Have you?
I tell your lordship, my lord, why it was not done, my lord. If your lordship kindly take the report that they have just submitted today, my lord. My lord, kindly see that they have not said when they have communicated this order. They have said that they have passed this order on 24/10/2024, first paragraph. Then their next date is 16/12/2024. That is the date when I affirmed the writ petition. So if something
Please
has
read that what he has said.
16/12/2024, the letter was issued by the Assistant Engineer PWD Roads, Chachol, to Superintendent of Police Malda and copy to Subdivisional Officer Chachol Malda to provide adequate police force to maintain law and order during removal of encroachments, madam. So this is not a communication to me. They have not said.
That is your argument.
Yes, madam. They have written to the SP.
Yes, 16th of. There are two aspects of it. First is your order was 24th October. You filed the writ petition 16 December. What is your contention? That till 16 December nothing was communicated.
On 10th, I got the order from the office of the district magistrate. When I went to the office of the district magistrate,
you collected on.
I collected the order.
So when you collected the order on 10th, after 2 months, show us one single letter you have issued that you ordered has.
Give me the order. I am told, my lord, we have given, my lord, getting it from me, my lord.
Now that aspect you have not reflected in your writ petition.
That's true, my lord. The reason why it was not done because, my lord,
but this is a court of equity.
My lord.
We have called upon him to ascertain whether this district magistrate was sitting over the top of our head or not.
Yes, ma'am.
If there had been any such situation, that is why we called upon him to come with this report. Because the majesty of the court is required to be maintained.
I completely bow down, my lord.
And in order to get this relief, you have to be very specific with your
governments, my lord.
Acha, come to the order which you challenged before the writ court 24th, this DM order. Yes. Come to the DM order, please.
Page 117.
My lord,
116, my lord.
My lord, that was illegible, so I have got a fresh copy for your lordship.
116.
116. Of the, my lord, this application, my lord. Hey, of the appeal, my lord. Stay application.
Show us what was your submission.
কেন এটা না? এটা
আমাকে একটা কপি দেবেন?
হ্যাঁ
Legible.
You are Muslim Ali.
No, my lord. Muslim Ali was the private respondent, my lord. I am 10, Gauri Shaha and others. Muslim Ali was the person, writ petitioner, as whose instance and for whose cause this eviction proceeding was initiated. The genesis of this eviction proceeding was at his instance, my lord.
Where is the order of the assistant engineer?
Lord, 115.
My lord, page 80.
Then 115 আছে,
No,
assistant
that is
engineer.
DM.
No, 115 is the take 3 order.
80, page 80.
District magistrate.
No, no. 11, Milord,
Five.
My lord, 100, 80, my lord.
80, Milord.
Page 80.
150 is the order passed
My
from
lord,
the
DM,
appeal.
DM. Appellate authority.
80, my lord. 80.
83, Milord, is the operating portion.
No, my lord, 80 last
83,
part,
83.
80 last part, the order ends. Order does not extend beyond page 80, my lord. 80 last part is the operating portion, my lord.
What is 83?
The 83 is the order passed by the executive magistrate under 10.3 to implement the order of the assistant engineer, my lord.
We took cognizance.
No, 10-1 is mere, Milord, initiation. 10-3 is the reasoned order.
My lord,
My lord will find at page 83.
Since your lordship is at page 80, kindly seize the reason behind passing this order recorded at the last few lines of the of that page, my lord. Well, I'm placing for your lordship, my lord. Under these circumstances, after performing site verification and after hearing the statements of all the parties present and considering all aspect and prospect of the instant matter, it is thereby ordered that the West Bengal Highway Act 1964 will be initiated for removal of encroachment on the government land in front of riot plot of the petitioner. My lord, this is important. For providing petitioners ingress and egress to the government land. So Muslim Ali complained.
It's not the order. It is just
Initiation. 10-1, my lord will kindly see.
order is 10.3.
10-3.
That is the
Page 83.
order which will determine your right.
I'm grateful, Milord.
Made.
Very well. Bow down.
ডিলারের একটা রিপোর্ট ছিল।
Page 84, my lord will find observation that it is public road.
These are illegal construction encroachment in front of fund of society.
Lord, may I say now, my lord? Lordships will only adjudicate, subject to correction, my lord, on can 2, my lord, only when I can establish before your lordship that the order passed by the honorable single bench, my lord, is not sustainable in the eye of law. Unless I can overcome that hurdle, my lord, in my respectful submission, can 2, my lord, may not come for your lordship consideration. Lordship can dismiss my appeal at the threshold, my lord, without considering can 2. My lord, in that perspective, my lord,
Can to why shall we go
Yes,
into
yes.
that now?
Because
the order has been implemented.
yes, but since, my lord, I am saying, my lord, it is my submission before your lordship, my lord, the implementation of that order has caused innumerable hardship to me by violating my fundamental rights recognized by your lordships, my lord. And in that perspective, my lord, if your lordships today holds, my lord, that there has been an injustice caused to me, then, my lord, in my respectful submission, lordship have all the power and authority, my lord, to undo the injustice that has been caused to me. If I cannot overcome that hurdle,
So what you are saying?
so, my lord, in that perspective, my lord, the first judgment that I will be placing before you.
No judgment. You show what is the fault.
Decision making.
Yes, my lord.
Decision making process, where is the fault?
Yes, kindly comes to the order impugned, my lord, the honorable single bench's order. My lord, that starts at page 118, my lord.
Page
118, my lord, of the
118, my lord.
of the CAN application.
Yes.
My lord, kindly takes, my lord, paragraph 119, which is the reasoning enforcement. And after the line which says, my lord, I have heard the parties at length. My lord, the next paragraph. The impugned order is based on a report submitted by the Block Land and Land Reform Officer, Horishandrapur Development Block, which states that the petitioner have encroached upon a section of the Public Works Department road. The petitioner have not challenged the finding of this report. Now, this was the reasoning by the honorable single bench, my lord. I say, my lord, I did not challenge this report because my admitted position from the very threshold is that I am in a government land. I am not disputing. Even today, I am saying, my lord, that I am in a government land. My lord, what was my contention? That I have been residing in this government land for some time long, like 30 to 40 years. And this is recorded in the order. I will just place before your lordships, my lord. Once I have been residing for 30 to 40 years in a land, the private respondent who also owns an adjoining land never had a problem with his ingress and egress for 40 years, comes before the honorable court and says that suddenly, without specifying the date in which his cause of action arose, submitted before your lordships, my lord, before the honorable single bench, that his ingress and egress has been obstructed by my unauthorized encroachment.
No, he has an alternative passage also.
That was not his submission. That is what the finding has recorded, my lord.
Very good, very good.
His case was
Admittedly, you are occupying a government land.
Admitted.
So your possession cannot be shielded in terms of these provisions of the unauthorized occupancy.
No, my lord.
You admit.
I admit, my lord.
So when you admit that you are having an adverse possession of a government land, for which the statute has been created, that what steps they can say.
My lord,
so your admission brings you to the bottleneck.
No, my lord, I subject to correction, my lord. I am admitting I am in a government land, my lord. If for a public purpose that land has to be vacated, I will vacate it, my lord. The government will make.
You have not vacated for 30 years.
That is not on public purpose. The proceeding was initiated by at the instance of a private individual who complained without making me a party that his ingress and egress has been obstructed. And on that premise, my lord, the order was passed by the honorable single bench. Now, if your lordships kindly takes one after another documents, which was part of my written notes of argument, which was directed to be considered by the district magistrate, by the honorable single bench, directed to the district magistrate to consider. None of them has been considered, my lord. All separation of material facts, my lord. The private respondent.
Now the punishment has been given.
My lord, that has caused.
We cannot restore you to possession of that land.
In that case,
may I please one?
Under the Highway Act, there is a fact-finding authority. Under 10(3), you are given opportunity of hearing, an opportunity to present your case, all of your document, etc., anything like that.
Yes, my lord.
Thereafter, there was an appellate authority. You preferred the appeal. Appeal was heard in your presence.
Yes, yes, my lord.
Now the judicial review.
Yes, my lord. But
if there is any fault in decision-making process, court can interfere. If no, court cannot.
My lord, kindly take.
You don't ask us to apply our mind as to the factual aspect.
Okay, my lord. Kindly take the order, my lord, at page 107 once. The order passed by the honorable single bench.
Yes.
Not sure, at least two cases we allowed to be filed by Lordship. At least two cases with Lordship.
Chakraborty has said.
Yes, my lord.
Has given in this way, we cannot.
My lord, kindly permit us to.
Two cases, my lord, at least.
Kindly permit us, man. Kindly. Two case laws, my lord. For your lordship assistance.
Yes, give it. Which judgment? Who is the proposition?
My lord, the judgment is reported in 2016 10 SBC, page 799, my lord. Ashik Ali, Akbar Ali, Gilani and others versus Nasir Hussain, Mehboobai, Chauhan and others, my lord. Kindly takes, my lord. Page 804, paragraph 13, my lord.
Extra copy আছে না? Check.
My lord, kindly takes, my lord, 13 fourth line from the top, my lord, the line starting with however. Lordship have it, my lord?
Yes.
Placing, my lord. However, considering the fact that some of the structures may be in existence for quite some time and have been tolerated for all these years, it may warrant a human approach to be taken by the state authorities. For that, the state government must evolve a comprehensive policy if already not in existence. And thereafter, the collector may proceed to take action in respect of such unauthorized occupation.
This you ought to have done in your purported 30 years of possession period. You ought to have approached the government that I am utilizing the land for my subsistence.
My lord,
You
kindly-
regularize
I
that.
have kindly takes my written notes of argument before the district.
So
magistrate.
if that was not considered, you came to this court. Did you come to this court at that juncture? Try to understand. You are making argument on the basis of a fact which you yourself did not agitate. Sir, all possession cannot be regularized.
I
What
am
is
not
the
seeking
next?
regularization.
What is the next judgment you have?
The next judgment is a celebrated judgment of Olga Tellis, my lord.
Olga Tellis.
My lord, kindly have, my lord. Just Olga Tellis. When judgment, my lord, relevant will be paragraph 32, read with 39 and 40, my lord.
এই citation বলে দাও।
My citation will be 1985, 3 Supreme Court cases, page 545.
Paragraph?
Paragraph, my lord. 32 read with 39 and 40, my lord. In 32, my lord, the status of a right to life has been escalated for such slum dwellers and persons of the kind that the petitioners are
32, 39 and
40, my lord.
42.
40, my lord. 40.
All right.
And my lord, may I place it, my lord? My lord, kindly take 32, my lord. Relevant will be, my lord, page 572. 1, 2, 3, 4, 5, 6. Seventh line from the top, my lord. And sentence starts with an equally, my lord. Lordship have it, my lord. And equally.
Yes.
My lord, placing, my lord. An equally important facet of that right is the right of livelihood, because no person can live without the means of living, that is the means of livelihood. If the right to livelihood is not treated as a part of the constitutional right to life, the easiest way of depriving a person of his right to life would be to deprive him of his means of livelihood to the point of abrogation, my lord. Such deprivation would not only denude the life of his...
Sir, you are not a slum dweller.
My lord, I am.
You were running business. You were conscious that I am occupying on a government land. But when nobody is complying, nobody is complaining, let me enjoy the same for an indefinite period.
Lordship is putting
Apply the judgment on the facts of the case. This is not a case that you were a slum dweller. Your right to livelihood was dependent. Your case is my right to livelihood was dependent of the shop which I was owning.
My lord.
I was getting a subsistence from that.
My lord.
So you ought to have regularized your possession.
I applied.
Having everything have been done, now you come and say, Olga Telly says it is a fundamental right, you cannot throw me out. It is very late on the date, sir. You know.
In this appeal is the
But unfortunately, we are not, we initially we thought, as such, we called for this instruction from him. And Mr. Chatterjee, the administration, these bureaucratic officers, they,
No,
anyway, less
we
said
can
the
do
better.
we can do little, Milord, other than Milord hanging our head to that. Milord. I will, Milord, take up the issue with the Milord. I'll certainly, Milord.
Yes.
Publisher was there only on the point of constitutional issue, my lord, the right to life and liberty. And that has been attacked.
Yes.
This is the very serious issue, my
We are
lord.
grateful, Milord.
They kindly be allowed there to the move to the village. This is constitutional issue, my lord.
Yes,
This
next
bill-
one.
My lord, I appear for the petitioner. My lord, we kindly
Appear on behalf of the respondent.
My lord, that matter, and my lord, the Union of India was supposed to give my
My lord,
lord,
affidavit,
affidavit
I'm
of
ready with
opposition, and my lord, the original applicant, my lord, was also supposed to give an opposition to the supplementary affidavit, my lord, that we have filed. My lord, we are yet to receive a copy of both. We have not
Lord,
received, Your Lordship.
I have dealt with the main as well as the supplementary affidavit in my affidavit in opposition. I'm supplying my learned friend a copy of the same.
You couldn't use reply.
No, Your Lordship, I'm being served today.
Yes, my lord. I have just now served her.
The affidavit in opposition to the supplementary affidavit.
No, my lord, to both the original writ as well as supplementary. I have dealt with both
The
of them.
petition as well as dealing with the amendment made in the writ petition as well as in the supplementary affidavit on filed on behalf of the respondent number 1 and 2.
ওইটা ওই 3 weeks করে দাও, রিপ্লাইটা 3 weeks করে দাও।
I'm grateful to that.
She gave you 3 weeks, file it and come. Yes, next.
I am for the respondent petition.
Assigned matter.
Assignment.
Now, where is your client now? This person appeared in person and mentioned.
Yes.
You were engaged when? You better control your clients. This way, sir, it doesn't happen.
But I have not instructed him to mention the matter.
But he has instructed,
Why,
taking
Sahib?
your name. Taking your name, I have an advocate, but he's not available, sir. You listen to me. This practice which the learned advocates are generating, it is harmful. The person has the audacity to say when it will be taken up, I do not know. I am left nowhere. Though I have an advocate, I am coming before you and mentioning. We cannot explain the intricacies of appearance to your client.
No, certainly not.
Because once maybe your advocate on record was approached, as we asked, he
After
must have also
mentioning,
said,
after mentioning, I am informed.
what mentioning?
After
We have
mentioning by the client.
Nobody mentioned. Client mentioned.
Client.
So when the client mentioned, why didn't you tell him? Then who asked you to mention when the advocate has been engaged by you? Was it not your responsibility, sir?
Twice I have mentioned earlier.
Sir, please don't harm the institution.
No.
Protect the institution.
I have no intention, my lord.
You have no intention, but you are being taken advantage of.
I am not taking any advantage.
You are not taking, your client is taking.
Yes.
He comes and says that advocate, I don't know where the advocate is. I'm mentioning, you may take it up. And so far as we told him that you are not the appellant, proceeding is not upon you.
Yes.
If you want the matter to be heard, then there is
Let
an
bring-
appeal. The problem is we try to explain. We just do not take it up, dismiss. We do not do that. That is why people get on their head. You show us what is the matter.
I am for the appellant.
Just
by the 25th July 2023,
just give us 2 minutes. It's a matter of 2021. Show us the order which you have challenged.
Yes,
You are the any other parties are there. State is there.
State, I find Mr. Abhishek Prasad earlier occasion.
No, the appeal has been admitted. Paper books filed.
Yes, kindly, 25th July 2023 order.
That we have seen.
There
Where
is
is the
a
paper?
direction to treat the application for appropriate order as paper.
23?
25th July 2023.
25th July.
25th July.
25th
July 25.
Of which year?
2023.
So appeal will be listed. Now, any paper book filed? You have
No,
filed?
as per direction of this Honorable Court, 25th July 2023, last paragraph, Your Lordship can list.
So the vacating application has not been disposed of as yet?
No. The last disposed of,
Where?
but in view of the order dated 25th July 2023, last portion.
Department is directed to produce can 7516.
Yes.
Which will be treated as paper book.
Paper.
Where is that can?
That can, there is a stay granted in that can application.
7516.
Stay was granted 11th March 2020.
7516 is here. Yes.
The impugn order, page 109.
What is the matter about?
The school has come challenging that order. This school is a de-getting school. The respondent number 1, petitioner's father, was a group D staff. He died in harness. Now he claimed for compassionate appointment. my lord, your lordship knows, my lord, the delegating schools, my lord, the only DA is, my lord, the provided by the government. Salary and other allowances being paid by the school from their own fund. So there is no scheme for giving appointment on compassionate ground in a delegating school. There is no scheme I find from the so far my lord, but the honorable single judge earlier occasion, so many petitions were filed to consider. Contempt has been filed. In a threat of contempt, DI has recorded his name in the roster for compassionate appointment. Ultimately, this improved order has been passed.
What did the court direct?
109 paid.
School, the court cannot permit the school. Where is the order of 29th April 2004?
That is page 43. Page 43. That has been quoted in the improved order.
When did the death occur?
Death occurred, my lord, the 20th February 1997.
21st October 1996.
Oh, 21st October
1996.
21st October 1996. Acha. What is your age now?
Age. দেখে নিচ্ছি। না না তো স্যার।
Have you attained the age of 60 years already?
Oh. 2 years, 2009.
Petition that you will take. 42 years in 2009.
56, 57.
2009 we are in 25.
5.
So how many years? 11 and 5?
16.
16
15
years.
to 16.
So 42 years, 16 years. 58.
56, 57, 58.
No.
57,
52
58.
plus 8, 40.
7 or
58.
58. একটু দাঁড়ান।
Are you interested?
Yes, kindly see the order, my lord, in the different writ petition. Kindly look to, my lord, the order which is at page.
Where is your client today?
Client কোথায়?
He will not come. He will not come because he mentioned.
No. He is present today. Kindly see page 50A.
Yeah.
Yes. কোথায়?
68 60 যদি হয় 8 31/12/2027.
Now the post of clerk is still vacant.
No. Another, my lord, the DI has approved, my lord, long before, my lord, there is no vacancy in the post of clerk.
2004 I have
Mr. Jana, your DI has said that he will be deemed to be in service.
Yes.
No, no, that is the 29th April.
Yes.
That is the order of this honorable.
Yes. Courts has interpreted that order saying that he will be deemed to be in service. Have you
No.
challenged that order?
In the melody,
You have not challenged that order. How can you take these points?
And kindly see the order which is at
And
page
the
57.
22nd July 2003 is still vacant.
Page 62 and 63.
এই অর্ডারটা পাস হলো 19 June 2009. Council relies on the show আছে. Also points that DI says that PK may be Yes, those are pages.
Yes, kindly see page 57. This is the order passed by the Honorable Justice K.J. Sengupta, as his lordship then was
29 January 2002.
2002. And kindly see the order is at operative part, page 59.
This was passed in the writ petition.
Writ petition.
This appeal is arising out of that writ.
No. Subsequently, another
order, but
order.
of the same writ.
No, different writ petition.
13399 of 98.
And that's order attained finality. Kindly look to page 59. There is a direction. I direct the school authority to prepare
59.
the service record.
Made to the DI and the same is not. Yes, where you are reading?
Page 59.
Yes.
Kindly see the middle portion, paragraph number 2. Therefore, I direct the school authority to prepare the service record of the deceased employee, namely the Gauri Shankar Upadhyay, the father of the petitioner, and shall disburse all the benefits which was available under the rules and contract of the employment, namely Provident Fund, Gratuity, Contributory Provident Fund, Pension, if there is any. And there shall be this shall be done within a period of 12 weeks from the date of communication of the order. As far as the case of the non-consideration of the compassionate appointment is concerned, I find that the application is prescribed form was duly made to the DI and which has been received, and this requires some consideration. I accept the argument of Mr. Das that DI has not applied his mind as he has failed to take note the aforesaid admitted position of the submission of the application in prescribed form. Mr. Mukherjee, however, contends that this application should have not been made to the DI directly. It should have been routed through school authority. I find there are documents in next page. In my view, if any application is made to the DI and the same is not in accordance with law, then the DI should have given a reply and the same was inappropriate one, but it was not done. Therefore, I cannot accept the order of DI to extend as above. I direct the DI concerned to register the aforesaid application in accordance with law and deal with the same.
Then what happened?
Thereafter, kindly see.
Page 62.
Page
Contempt application.
61.
61, my lord, the post has been filled up by the DI.
Just.
The district inspector of school issued a letter to the learned advocate, Bar Association, room number 10, the learned advocate on behalf of the petitioner, saying that in response of his letter dated such as such, the undersigned would like to inform that in compliance with the solemn order passed on such and such, in WPA number 13399W of 1998, the name of Lalji Upadhyay, son of Gauri Shankar Upadhyay.
This is the writ petitioner.
Writ petitioner. Was enlisted in died in harness register. Yes, my lord.
X group D staff. Oh, the father.
Father.
Was it?
His father was the group.
His name will be forwarded for consideration.
For the post of
yes.
DA getting school and when opportunity will available.
Then what?
Then kindly see page 62.
Yes.
The petitioner, my lord, filed an application for contempt against the non-consideration. Then kindly see what was the direction. Type copy ache, type copy neyi. Kindly see the last paragraph, page 62. The petitioner's name, it is recorded that the petitioner's name has been registered in the category of died in harness. However, this has been registered with a prospective effect, not in terms and spirit of my order. It is seen that the post
My
of a
order means which order?
order dated 21st
29 January.
29 January 2002. It would be open for the school authority to take a decision whether the post should be filled up or not. If the post is required to be filled up, if then intimation shall be given to the district inspector of schools, and the petitioner's name shall be forwarded to filling up for the post after asking a preliminary examination and test of the petitioner as to his minimum suitability. Therefore, the matter is adjourned for a period of 4 weeks for the time being. Then kindly see.
The school
Page
hardening.
42.
Page 65 before that, my lord, the DI has approved.
Page 42A.
Page 42A.
A. This is a type copy of the 42A of the stay application. At the page 42, illegible copy is there, then type copy.
What you are showing, tell us.
So this is the instruction issued by the district inspector of school in saying that he is requested to appoint to the secretary of the school is directed to appoint the petitioner.
You can read it, sir.
Yes.
You can read this letter. I am not being able to read it.
Page 42A type copy is there.
Achha.
Kindly see, in compliance with the Honorable High Court's order dated 22nd July 2003, that is in the contempt jurisdiction by His Lordship the Honorable Justice Mr. K.J. Sengupta of the Honorable High Court at Calcutta, and considering the GO number dated 12th October 1987, he is hereby requested to appoint Lalji Upadhyay, immediate son of late Gauri Shankar Upadhyay, ex-group D staff of the school, on compassionate ground in any vacancy of the school, preferably in the vacancy of clerk. Thereafter, kindly come to.
Then what happened?
Then my lord, petitioner joined in the post school on 28th April 2004.
28th
April 2004.
Where do we find it?
Kindly see the averment in the writ petition.
Yeah, but
No. He never joined.
Come to page 66. This is what you showed at page 42A.
Yes.
Now show the memo of 12th October 87.
Memo of 12th
October 87, because his contention is school, in de-getting school, there is no provision for compassionate
apartment.
You satisfy us that there is a provision, we will dismiss the appeal, you go and file contempt and get your appointment. That is his only ground. He has never agitated that earlier. That is his ground of appeal now.
Kindly first of all consider page 43A. What has happened after the order passed in contempt jurisdiction, they filed an application for modification.
Yes.
I joined in the school, but they registered me to enter into the school. They lodged a complaint before the police authority. Now kindly look to page 43A. What was the order?
This is in connection with the contempt.
No, there is a specific. Kindly see. May I read the order? 43A.
This is an order of 29th April 2004.
2004. 28 April I joined. 28 I joined. 28.
There shall not until further order be entered the school till the application is heard out.
The modification application preferred by the school authority.
Modification of which order?
Order 29th January
20 April 2004.
Come back, we will hear.
And subsequently that modification application also dismissed.
You have heard his challenge. You show us that there is a scheme for grant of compassionate appointment in DA.
Yes.
That is his sole ground of challenge. You satisfy us on that. If he cannot satisfy, we will dismiss the appeal. But the thing is that it is of date is of 1996.
1990, my first application. Yes. Several writ petitions since 2002. I am fighting.
The hardly learned advocates appearing for the response. Now, what you will produce before this court? The memo of these two.
87, sir.
Learned advocates appearing for the appellants and the petitioner to private response. Is the matter for further consideration under the same heading on 20th January.
The appellant. No.
You show which are the
Yes, madam.
whatever circular you have, you bring a compilation of this.
Yes. Yes, madam.
You can bring, then we can hear. Otherwise,
Okay.